Item number 6.
I don't know what is madam. I mean, some document madam. I want to bring on important because finding an additional activity. I will allow to 1 week.
These are top of the list matters.
The municipal board also issued the one trade license in the name of the petitioner. And the municipal board of the Bombay municipal has issued the trade license. Earlier, my trade license was cancelled. Therefore, I am coming for the. Therefore, I want to bring these documents. Development one thing.
Well, let's see. We'll take up the matter and then we'll look into it. Hmm? Why? I've directed.
The director of minorities by 6.
We'll have it some other day then. Your name? You are for a Mr. D. Kulta, appearing on behalf of the respondent number 2 and 3, submits that an affidavit would be filed. Affidavit as directed by this court is in the process of being filed today. Let the matter be listed. We'll have it after vacations.
Right.
Let the matter be listed immediately after the vacations. Hmm? You want to bring it on record? Or do you want to do it or not? That's the matter out there. Yes. What has happened? You are for the GMDA. I've asked about that GMDA, no, GMC, as to whether it is permissible. Okay. You have filed the affidavit. Let's take it. You have not been given a copy. Hello, we'll take up the matter. Let's see.
I don't know how you are.
One piece of matter.
There were 2 violations.
Call for something, no? The scan copy of the AI has come. Document is not there. That document is not there.
So this is mentioned in the case diary. In case diary of scan copy. However, I could not procure a certified copy for that. But in the case diary, a detail has been mentioned in there. All the contentions that are forwarded to the police station. In the subscription document might not be just there mentioned in the case diary.
Is there everything is in Hindi?
Unfortunately.
Then how do you know? Fantastic. This is not a part of his. This is not a part of it.
Unfortunately, I couldn't procure the certified copy. And giving a little time, my lord. 6 weeks after Punjab, these people are able to get the when the case diary was mentioned, all the entire record is there, entire document is there.
You have not filed the additional affidavit?
So I find
When?
starts from page number 49.
40? What page? Pursuant to my directions last time?
No, not last time, madam. Before that, I was
That you have
Well,
filed,
no, I have
that
not
I
received.
know.
Well, I have not received the madam certificate. So it's not filed. Person to return time.
Now, this is a typed as translated copy of the relevant portion. What is this?
Page number 15, 53 onwards, madam. This is the document which is submitted. The translated copy of the.
This court, this court by the order dated 12/9/2023 calls for the scan copy of the GR case number 44/2016 in connection with charge sheet number 73/2016 pending before the court of the JMFC Bokaro. A perusal of the said case records, however, so that pursuant thereto, it reveals from the records that a scanned copy of the GR case number 44/2016 was received by the registry and had been put up before this court. Upon perusal of the entire case, the scan copy of the GR case number 44 of the 2016. The document dated 15/12/2015, which have been enclosed to the additional affidavit filed with respondent number 4, is not a part of the said record. This court further by the order dated 12/9/2023 directed the respondent number 4 to produce the certified copy of the communication dated 15/12/2015, which as per the respondent number 4 forms the part of the FIR. Mr. So and so appearing on behalf of the respondent number 4 seeks for an accommodation of 15 days for the purpose of obtaining the certified copy. This court accordingly fixes this matter again on 9th of November 2023. It is made clear that no further opportunity shall be given to the respondent number 4. If the said certified copy is not produced as earlier directed on 12/9/2023.
I'm being item number 1 for the.
You want to withdraw?
Yes.
Withdraw. Means that he has instructions to withdraw the instant requisition. Accordingly, the petition stands to.
No, 5 permission.
I've asked them to file an affidavit.
They have.
They have filed it. Not filed. No, this, the lady out here, I think, who was representing the GMC, said that they are in the process of filing, didn't mention.
It is very honest and frank. I have checked. There is no permission which is granted by any. They can be very honest. Only a trade license is granted. That I don't know. There is an order passed by this court. Again, I have got to. You cannot use it. I have seen that. I have the person is right. We have to show it. How it has been granted. How am I running it? On the basis of a trade license. Whether on the basis of a trade license without a valid permission. There has to be a permission to be given. This is what your lordship is asking to be replied. Before your lordship.
More particularly, it's not a question of permission. It was the building was residential.
Correct.
And this court on the last occasion had passed the order and gave you the liberty out here to use it because you wanted to use it for your son's marriage.
Right.
Now, thereupon the GMC grants a trade license. But can you do it unless when this court made it clear that it cannot be done unless you change the,
Granting of a trade license doesn't mean that there has to be some permission to be given.
there has to be a conversion.
That has a conversion, that permission. I have asked
Whether the permission is not there or not. What is the effect of a trade license?
Trade license is
There
only
has
a,
been permission. There has been permission being given by the GMDA. We have to show it. Where is the permission which is given by GMDA? I think I'm aware of it.
because trade license will come within the ambit of 183. A license which is being given only for the purpose of collection of professional taxes.
But trade license is separate. So there has to be some permission which is given. Or whether I can use it under the law for that purpose. That your lordship has to do. Suppose for a moment, the permission is not done. Suppose for a moment, permission is not issued. For commercial use. So then what happens? Under the law, whether I get a benefit out of it, whether I can use it in a residential purpose, then they have to explain.
No, in fact, my opinion is that you cannot, because of the fact, the reason why you cannot, just let's take the example for mutation.
Yes.
Mutation is only for the purpose of collection of tax. Although there has been a wrong notion everywhere that mutation confers title, no.
Yes.
So on the basis of a mutation, you cannot say that you are the owner of the pit or assessment being done. You can even for example, an assessment being done could not legalize an illegal construction. That has been held in that Sujata Pathak's judgment of the division bench as well as in Priyanka Estates. So the matter is very clear on that. So even if an assessment is being done, even if a trade license is, because trade license is only a levy, right? For a purpose of levy. Yes, madam. Huh? Who? What about the affidavit? What? So what is your stand in your affidavit? Huh? Why? There's only one GMC council in the High Court. So then get hold of the other two. This court is going to go as per the allotment. So we pass an order, go to the court number 1, then file an appeal. Better off if you want to do that. We have asked the GMC person to file the affidavit by 6:10. You have not filed it. We asked the commissioner GMC to be present. You are not concerned. Sorry, you have not given a copy. Let the commissioner GMC be present at 2 o'clock. He has not filed it. We'll give the virtual link. Appear to the virtual link. He need not come over. No. Virtual link, 2 o'clock. Let the commissioner GMC be there. Virtual, he need not come. Ask the Manukita for you. Give him the virtual link. 2 o'clock we'll have it. Personally, let him be there in the virtual link.
Number 6.
Time being? What is the time being business?
Yes, so we will identify the benefit to 5 on because on the challenge.
Oh, that one.
Yes.
Ah.
They are not related to the second case. There are 4 of my. Yes,
as you have filed the affidavit, let us give them some time for a response. Pursuant to the order dated 10/8/2023, passed by this court. An affidavit has been filed by the Additional Commissioner of CGST and Central Excise GST Bhavan and Central Excise today. On 7/10/2023. The petitioner is given 2 weeks' time to respond to the same. List the matter again on 14th of November. Yes, we'll take it up 2 o'clock virtually. Virtually. No, you go. We'll have the commission.
One more issue is there, the lordship give us side to money to scheme lordship for evaluating the flood affected assets. Yes.
Why won't you have it on virtually? I don't want him physical
So
PVP.
lordship, we have filed the affidavit.
But you have not. You were supposed to file it on 6th.
Lordship, it's-
Why do I give a time earlier? You don't give any relevance to that.
Only that order of people is only on authority.
So
So immediately I said.
were you not present on the day when the order was passed?
Whether I have already informed,
Then-
but, the commissioner was not there, not, that is the only reason was in front of the This is the only reason. Consequently, commissioner, where comes the lot, or tomorrow also.
No, let us hear the commissioner at 2 o'clock. I've asked him to do it virtually. He need not come.
So my presence.
You have 3 councils, let anybody of them be present. Because you were not there at that point of time. So, and the affidavit was directed to be filed on 6th. You have not filed it. Have you explained why you have not filed it on 6th? Have you filed it? When the court directs you to file an affidavit on a particular date, you have to file it on that day. You don't give any relevance to the dates being fixed. Why do I fix a date 4 or 5 days before so that I can, the other side gets an opportunity? Or am I doing a meaningless exercise out there fixing a date? Then-
The site of the only yesterday meeting. That is why it's not that copy.
You couldn't serve the copy to the other side, and it is only a very specific point urged to the, which I have asked you, as to whether could you have issued that license in view of the order being passed?
Yes, Lordship, we have indicated that in view of the order passed by your lordship, earlier lordship. It was not permissible for us, but inadvertently, and it was issued on an online mode lordship, it was issued without any physical verification. That was the only reason. Otherwise, it's not.
Okay, we'll take it up at 12.
Well, okay.
I inform the other sides.
Sure.
And get the affidavit by that. No. 12 o'clock.
Yes.
No, 7 and 8.
Huh? Why? What is this matter about? You're still running. Then where is the, why an interim order is required?
But I was entitled for 5 years and then there was a renewal matter. We talked with the contract. But they have issued a tender for that.
No, it's wrong one. Actually, they are,
tender process has been stayed?
Yes, madam. My daughter will get.
Yes, 4/8/2021.
That is not finalized tender. But in this tender notice, this is that running business in a wheelbarrow, which is not included in the tender. So tender is not related to wheelbarrow. Wheelbarrow is a mobile unit, which is used by the hands and selling the.
Where is the tender?
Tender is annexed, sir.
Page, my lord. For register policy.
30?
59, my lord.
Hmm. No, no.
No, no.
Where is the tender?
Case 67.
Page 67. What are you doing? What is your business?
One is a tea stall, one is a wheelbarrow.
Both of them to wheelbarrow. Not a piece of, it's a wheelbarrow.
Where is the wheelbarrow out here?
But the new policy, Lord, they have no provision. So far as wheelbarrow is concerned. And they are.
So this is not going to affect you, as she says.
But they are not used. I have.
No, she says that this is not going to affect you. We take that undertaking, we vacate the order.
But the lordship would kindly take at 2, my lord.
No, we vacate that order. No, mister. She says, no, your only anxiety about this tender is that if this tender works, your wheelbarrow has been put to stay. She says that the wheelbarrow is not. So,
They have taken it, what has happened, my lord? That my father has expired, my lord. I have a right of inherit that, because in terms of the contract. So they don't renew my license and they don't recognize me and they issue the tender. Now, since they have not allowed me to continue, but they have thrown the wheelbarrow out. And now they have issued a tender.
where is the wheelbarrow? The wheelbarrow is not there in the NIT.
But not email of the tender, the license is not concerned. We are already, the license was issued to the original holder and we were extended up to 2015 to 2020. And we expired on 2019 and 2019.
One-time extension given.
Yes, yes, it is given.
How many times extension you have?
In terms of the contract itself, says that I am further entitled.
Where? In 2018, Annexure 1,
Yes,
where is the clause?
at 3.2, my lord, I take petition.
Clause 3.2. The tenure of the license shall be initially for a period of 5 years with the provision of a further renewal for a period on satisfactory. Renewal will not be a matter of right. The license must apply for renewal 6 months in advance before the expiry. No due certificate for mayor must be attached. The license must submit the documents addressed along with the renewal application. So this is done in 2018.
Expired.
Who is the original vendor?
Then, number 7, okay, then some,
Sa. Okay. And whether it devolves upon the you?
Yes.
Where?
But in terms of the clause itself,
Where? Which clause? Are you saying that it includes so and so? Where? Under which clause?
that's for the license.
90.4, my lord, page 30.
Transfer of license to the spouse would be allowed only in the event of the death of so and so. The license can be transferred in the name of the spouse, legal heir, or for the unexpired period of the agreement only with the personal approval of the chief. Man shall obtain the nomination of the legal heir on the license holder at the time. Now, did the nomination was made?
Yes, my lord, we have, my lord will see page 710.
Paid?
The legal year certificate.
No. Was the nomination made at the time of death, at the time of entering into the agreement?
That was not required,
No, it is required. See 19.4.
my lord. The legal shall obtain the nomination of the license at the time. They have not obtained.
They have not obtained, but you have not exercised that. And anyways, only for the unexpired period.
Yes.
Only for the unexpired period. That is as per the 19.4. You don't get any further right beyond that. Because your period is over as of now. 5 years is gone. 5 years is gone.
They reject me on
I'm not concerned. As of now, as per this agreement, you cannot, because the period is over.
the period starts at 1/11/2015. It ends on 30/10.
No, we have to go as per the master license agreement,
Yes, sir, that's
which
what
is
I
at
said.
page 19. The agreement is dated 5th of September 2018.
Other would kindly see clause 1.1. If Millard, it has been lately entered Millard, it has been given effect from 2015.
So then 20 is over.
But he expired in 20 Millard, prior to my expiry of period. And then once Millard,
No, then you don't have right.
But once I enter the shoes of the.
No, you don't have right.
But I have a right of renewal, my lord.
No, as per 19.4, it is not. That right is not.
Then the lordship would take at 2, my lord. I'll
No.
satisfy your lord.
I'll do one thing. We'll have it after vacation, but I'm vacating the interim.
But then lordship may kindly take at 2, my lord.
No,
Or
you do it
tomorrow-
now.
or Tomorrow.
We have already heard it. What else?
But I have listened.
What else?
My lord will kindly.
No.
Will kindly see this.
You don't have a right beyond that.
But if they allow me, your lordship will see the rejection letter at page 59. my lord.
Please refer to the letter of event dated wherein you have advised to submit the succession certificate for transfer of the event, but the same has not been submitted till now from your end. In this scenario, the matter for renewal of the area does not arise. In view of the above, you are given the allowed to submit the succession certificate for transfer of the wheelbarrow license, which was in favor of so within 7 days, failing which your action as deemed fit and proper shall be taken by the regulators. Yes, then
Sir, the house being built, I would have got tenure till 30th of October. And then my right of renewal would approve, my lord.
no, where is your right of renewal? The only you are only entitled for the unexpired period. Nothing more than that.
Your lordship read with.
No, why should I? No.
Can I make one fair?
Yes.
This wheelbarrow, they are not concerned, lord. Your lordship may vacate that. But take it after vacation, lord. I'll satisfy your lordship whether I have a entitlement or not.
So they can go ahead with the tender? They can go ahead with the tender?
Yes, they have already gone ahead with that.
Then what happened? You have not settled it. You can go ahead with the
They have
tender.
already allotted the, because they say that wheelbarrow is not within the purview. So this order is otherwise also not effective for them. So whatever the.
So then why do you need the interim order?
It may be vacated by the, because it is not related to this case, sir.
Because the interim order says till the next date and initiated under the NIT dated shall not be finally in respect of wheelbarrow stalls standing at platform number so and so. But you are not concerned with wheelbarrow.
I have one concern.
Then why are you concerned with the interim order?
Second also, I don't have any problem because my tender notice is not involved with the wheelbarrow. So I have right to continue that purpose. But on the basis of this order of the honorable court, I think deleted. Because I was not directed to finalize this.
Only for a wheelbarrow, we make it clear.
Yes, madam.
We'll have it after vacation. The petitioner herein claims rights to continue on the basis of the master license agreement entered into between the railways and the father of the petition on 5/9/2018, which was given effect from 1/11/2015. The claim of the petitioner herein that by virtue of clause 19.4, the license was transferable to the spouse oblique the legal heir of the licensee. It is under such circumstances the petitioner claims that the petitioner has a right to continue on the basis of the license which was issued in favor of the petitioner, in favor of the father of the petitioner. On the other hand, Ms. U. Chakravarti, the learned counsel appearing on behalf of the railways, submits that the transfer of license would only be applicable for the unexpired period. And as such, the period have already expired on 31/10/2020. It is further mentioned that the petitioner thereupon has no rights to continue with this wheelbarrow business on the basis of the said license, on the basis of the master agreement dated 5/9/2018. She further submitted that an order has been passed by this court, an interim order has been passed by this court on 4/8/2021, whereby the tender process initiated under the NIT dated 2/7/2021 have been directed not to be finalized in respect of the wheelbarrow stall standing at Palakata platform number 1. And the said order is affecting the rights of the railways to stop. It is also the submission of Mrs. U. Chakravarti, the learned counsel appearing on behalf of the railways, that a perusal of the NIT dated 2/7/2021 would also show that the wheelbarrow stall is not a part of the said tender. Mr. R. Dubey further also, while rejoining to the submission made by Mrs. U. Chakravarti, submits that the petitioner is carrying on the business on the basis of the master agreement in the wheelbarrow stall standing at Palakata platform number 1. And if the respondent, if the railways stand is that the NIT dated 2/7/2021 has no relevance to the wheelbarrow stall which the petitioner is operating. The petitioner has no objection in respect to the finalization of the said NIT. So, taking into account the above submissions, this court permits the railway authorities to proceed with the NIT dated 2/7/2021. In doing so, it is made clear that the wheelbarrow stall at Falakata railway station, platform number 1, Falakata platform number 1, shall not be a part of the said NIT dated 2/7/2021. The matter having been heard at length would be taken up for further consideration on 7th of November at the top of the list. What? Not necessary. Arthur means it is going against you. Don't make that. If I am not sitting out here on 7, you'll be happy enough.
Second one, regarding a tea stall.
There is also a stay. And is it affecting?
Same matter. So, wheelbarrow.
No, it's a tea stall.
Already by wheelbarrow, madam.
Wheelbarrow. No, this is tea stall. Here also that
Tea stall, because they are mentioning the tea stall instead of wheelbarrow. Actually, it is a wheelbarrow, not a tea stall.
The agreement is not very clearly. The licensee has been.
no, this agreement at Alipurduar Junction.
Yes, ma'am.
And what has happened? Why here you have a problem? Same.
Same. I will also see clause T of page 19, madam, where clause is there.
No, this is a stay as regard a tea stall.
Yes.
But the tea stall you have put it in the NIT.
No, madam, it's not tea stall. My exhibit already I mentioned in there.
No, shall not be finalized in respect of the tea stall standing at Falakata platform number 1.
But my second, record number 8, it is not tea stall, it's also wheelbarrow. Already in my there are 2B, I already mentioned, madam, that page 4, my executive position, the education of regarding general licensing name after dates of his father is in policy management of catering policy 2010 and got 19.4 of the agreement dated 5/9/2018, which is between legal and with them. Moreover, the fiction has failed to establish or providing evidence for such a claim in the event of his father days of 10/10/2018 was the original licensee during unspecified period of agreement. It will be noted that the original contract agreement was expired on 31/10/2020. This is after date of the original licensee, but the petitioner claims the custom license in the name of in his name in violation of para 21 of the Catering Policy 2010 dated 27/10/2010 and clause 19.4 of the agreement dated 5/9/2018.
Here also it is the same, only transferred for the unexpired period. And the period ended when?
The
First 10,
Huh?
31st 10, madam.
No, same.
it expired on 10/10/2020.
Madam will kindly see one aspect, madam.
The father of the petitioner expired on 10/10/2020 and the contract agreement was expired on.
No. This agreement is different. Huh? It is same?
Same, madam.
Oh, yes. No, yeah, no. Here it is different. See the date? 1/11/2000. What is it?
From 1/11/2015 to 31st.
This is what, 15, 15. So same.
Same, madam.
But here you don't have a case.
Madam will be clause C, madam. Clause-
For what? No, clause 3 doesn't have.
Madam, please, that I have wanted to pursue your lordship on.
So, we will also have written here.
Has been agreed for a period and subject to the provisions of Siman and Article here shall continue until a period of 5 years from the government comment, and if not terminated, expired will be renewed or mutually agreed.
Taken note of by the railway authority. 3 years. But the review was filed. Questions were raised before the parliament, my lord. They have given it. So that was the issue. So those I am trying to.
Sorry.
answer your lordship for that.
Enough. Hey, I got order to cancel. I'll pass the judgment at 2.
Take it as, my lord,
You say that 2. Enough. Too much I've heard.
my lord,
We'll pass the judgment at 2.
my lord,
2 o'clock, nothing more. You have asked for 2, that is it. Enough. You don't have a case beyond that. I think before that you can go to the division bench. Enough. You have heard, I passed that order, you should have been more happy not to say anything. But as I have heard so much, no, Mr. Dubey, this matter have been heard at length. So you also wanted this to be parted. So you see the end of the day, you should not see the sunlight tomorrow. A new things should come up new tomorrow
that's the.
at 2 o'clock. We'll dispose it of. Hey, I got order to cancel them. Enough, I'll pass the judgment in your presence.
But I have already come up with that.
2 o'clock, I've heard, I'm passing the
So,
judgment.
your lordship then permit me to make some,
Yes, you make 2 o'clock. Nothing more.
Number 9. This matter of what the appeal is filed,
What happened to the 2017 policy judgment?
They went to the Supreme Court. Now they have filed a review petition. Now they're on a delay.
my lord. For,
Before whom?
for the, court number 1.
Demand demanded by the apex court.
Not exactly demanded by the.
As he told me.
My thought. My lord, actually, we have filed a SAP for the, honorable Supreme Court. The matter was hard at time, then, it was, found out that there are 2 sets of judgments were there. One is on the area and another is, the series of the police. My lord, in that area, there is a area case, my lord, there was a division bench order. In that term, my lord, the policy which we challenge, in that term also that similar judgment was passed, but that policy matter was not started. So, honorable Supreme Court said, go and raise this issue. Then we withdraw it, we have liberty to file the review in the court.
I appeared for the case. In the first case, there was a change in office. As against that, when the appeal was prepared, I was very. The court was trying to interfere with the order pathway or say. Then we agreed for a different type of order. So policy, with respect to policy, whatever the lordship was, remain given. Subsequent rejected file, they are not directly involved. So that way, your lordship's order passed by one signature, but upheld by the.
No, because I want it because that is comes at 2 o'clock, I'm passing the judgment.
Right.
So there also there's some touch on the 2017 because that he's making on the 2010 policy, this particular thing was given.
But in our.
One of the, one of one passed other.
No, it's okay, but
My lord has pointed out one thing in the particularly, that policy is a decision of the government. So it cannot be interpreted unless and until.
arbitrary.
Yeah. So, my lord, that point, we have raised in that, only one thing is, involved is livelihood. If there are lots of judgment, and then, Supreme Court's order also, that in view of the livelihood, the minor category units will be, allowed to pay. This is a 2010 policy.
But that is given in 2010.
Then we say, my lord, that for particular livelihood issue is, was not, my lord, discussed in the legal system. That is where we are agreeing. So, tomorrow it is.
But anyway, the question, because you cannot have a livelihood, in my opinion, I don't know what the division bench may say. Because these are all state lodges. The problem is you can't have a livelihood, only consider the livelihood of Mr. B. Sharma and not consider the livelihood of Mr. T.H. Hazarika. The moment you only consider him as on the basis of a policy which is not there, then it becomes violative of Article 14 again.
Add on to the minor products. Yes.
Which one?
No, not.
Oh, that one.
Upholding.
But my lord, only here that.
In fact, my lord, not think otherwise. Lordship has the occasion to deal with the 2017 policy, not because it's only a matter of policy. Your lordship entered into the merit of the 2017 policy and your lordship entered no. 7 policy will hold it.
No, I only wanted because I passed the judgment there, which may have a touching on that.
Yes.
Because there initially it was under 2010, then 5 years has gone, another 5 years has gone, now another they are asking for another 5 years. Because now, can it be given in view of the 2017?
This
So,
if I think
the unexpired, period.
and
That's
my
what I'm like. Let us do.
exception is not permitted under the 70 policy. Then it was there.
No, but can it be for 10? Can it continue for all times?
Cannot, my lord.
When
Most of-
2017 has come in?
Cannot matter and most of it after 70 policy came in fact, in that January, against the agreement pending, there issue was also there. That under 2010, there was a provision for extension. 17 there is no, so it also there is no 70 policy will kick in simply. And in that context, your lordship is,
No, but during the pendency of an agreement, if the 17 policy kicks in, then the agreement will prevail.
another.
No, during the pendency of an agreement, if the 17 policy kicks in, my opinion is that the agreement will prevail.
But in all cases.
But the policy cannot override the expressed agreement. But if there was no agreement, then the policy would prevail.
I know only one point we have raised that 2017 policy came up. Corresponding to 2010, only because of the Supreme Court order.
That is year's case.
Because
That is
Supreme Court
too
held that the-
much.
They have the right to livelihood. Right?
That
Anyway,
is-
but tomorrow
anyway.
maybe some.
No, that is another thing.
2 o'clock along with that matter.
Huh?
So the lordship meeting, take up matter along with that matter. Give, sir.
Why? What is this matter? No, what is this matter? Oh, that one. I asked you something.
If I has filed the-
Just file the academic.
It is relevant to take note from Annex 11 that the total sale of, oh, this one. Mr. B. Sharma appearing on your submits that he would like to file an affidavit. Oh, because I asked you a specific question in this matter as to whether this could have been done so, taking into account that,
Whether they were making profit or not.
yes, the profit was there or not.
They
Because-
filed the affidavit.
Because you say in the COVID period, there was no profit. But what was it prior to that in 2019-20?
In that case.
Another aspect, madam.
Yes.
2019, we sold a Dhosha at ₹30. They are selling at 70, madam. I have that. So they are not giving the menu. We just have to buy one and get the receipt, madam.
Otherwise,
They can be double.
they have
We are
some
giving 22
profit
lakhs
of
and they are
7 lakhs.
20.
They have shown some profit of 7
That's
lakhs something.
20. When we were selling.
And without deducting the salary, if the salary of fixed staff involved in this whole process is taken into consideration. So
Now you have filed an affidavit.
Just now.
You want to file reply? Against that. File a reply if you want. If you want to bring, don't bring all these things out here, these case memos like this. No, nothing there. But this needs to be on record. Because these are things which developed during the course of hearing.
Yeah.
As to, because initially it was not something like that, but when it was taken up, more particularly on the last occasion, while seeing their papers, it transpired one thing, that your or the decision was taken, or the policy decision was taken to put on sale or put on area the lease, the state catering business, instead of working by themselves on the basis that your performance in 2020 was not good. That was the reason. Now, therefore, this court had directed them to file an affidavit as to whether they had taken into consideration the earlier period and whether it was good or bad. Because 2020 could not have been taken into account because that was a policy reviewing where the trains were not running, nothing was good, the people were not running. And that is also has been stated by some inspector, whom he claimed that he is paying it to work for you.
that inspector yesterday evening he had submitted a statement. As per that statement, there is a profit of 7 lakhs. So far the limit of the petitioner is concerned, but that statement doesn't take into consideration the salary paid to the 3 staff. At least the salary would be 50,000 per month. So there are.
Anyways, you have filed an affidavit that is not on record.
Just now.
Okay, Mr. B. Sharma, the learned counsel appearing on behalf of the petitioner, on behalf of the railway, submits that an affidavit has been filed pursuant to the directions passed by this court on 26/9/2023. Mr. T. H. Hazarika, the learned counsel appearing on behalf of the petitioner, upon receipt of the, have also received a copy of it and submits that he would like to file a short reply to the same. Lists the matter again on 9th of November 2023 for further consideration. After writing so much things that I've recorded, you are paying 22 lakhs. But you see, the reason why they have taken the decision is that 2020 it was not good.
They cannot, at that time, predict whatever is on today. Issue was whether my not tendency of my agreement can they protest tender. That is right.
We'll complete it on 9.
But they have already floated.
They have already protested.
They have already settled.
My lord,
Now, do you want me to unsettle things which have already been settled?
but my client says, my lord, at any cost, my lord, today you will have even more profit. Yes,
But why didn't you participate when the tender was
no,
issued?
because I was clearing on my lord. After the tender, my lord, one fine day. they
So
have-
we will consider it online. Put all these things.
I don't like the information.
Oh, CD,
Yeah, yes, the record was also possible.
got the CD?
I have verified the record, but it's not there. It has not also come from CPM and. I also-
But one thing I'm asking you, oh, this is a title pages there with some title pages, scan copy. Stay. No, the thing is like this. Here, obviously the CD would not be here. The reason is why the CD would not be here is in view of section 100, because on that day you said that the CD would be there with the case diary. Case, the charge sheet?
Along with this, normally the case that you have submitted.
No, it cannot be. Because if you see that day I was looking into it, CRPC form.
I don't, when they furnish charge sheet, they rely on all the materials.
No, Mr. Vishwas.
Copy of all those has
No,
been
no,
given to the
no,
accused for the-
No.
It's submitted- it's submitted.
Kindly come to section 172 of the CRPC,
170.
72. As a criminal code rules and order conditions.
Yes, diary of proceeding.
Every police officer making an investigation under this chapter shall day by day enter his proceedings in the investigation in a diary setting forth the time at which the information reached him, the time at which he began and closed his investigation, the place or places visited by him, and a statement of the circumstances asserted through it. The statement and any criminal court, now kindly see this. This diary is never submitted. Any criminal court may send for the police diary of a case under inquiry or trial in such court and may use such diary not as evidence in the case, but in aid it in such inquiry or trial. Now, if you see the civil criminal rules and orders, it will say which are the documents to be marked. Only evidence can be marked, and which is not marked has to be returned. So the case diary can never be a part of the records.
I don't, what I understand, I'm not saying that the case is the part. What I'm saying, my lord, the police, while furnishing a report under 173, my lord, will submit all those documents which they have relied,
But not the case diary.
not the case.
Because no, case diary has to be called. The criminal court will call for the case, and then only it will.
In case.
If you see the criminal rules and orders, now this court is not criminal, so it doesn't move. Where is it? Criminal rules and orders, you'll find it. What are the documents to be kept, and upon completion of the trial, any other documents are left, have to be given back. And as such must have been given back. Here's it.
Because there is a.
Is there? What happened?
I'm saying, but they are not.
Oh, I have already written the judgment, everything is there, only thing is this. Because that 93 judgment squarely covers your issue, huh? And then have you seen the Justice Suraj Govindra's judgment of Karnataka High Court?
Last time.
Yes, have you seen that? It takes care. And another very important thing which he has mentioned out there, that there is a requirement to insert, inform the magistrate. I'll just show it. Where is it? Hey, another judgment के तहत switch look हो तो doesn't it? You could go. Ah, yeah.
I spoke by officer of NAFTA, Hyderabad,
Hmm.
on this day that I somehow, but next time when I start, I could not find it in the net.
Here he said, a very important thing, this is a very important aspect which needs to be, I think we can incorporate it also. You see, no person, whether he be an accused, under trial prisoner or convict, shall be handcuffed unless the reason for same is recorded in the case diary and or relevant records as to why such a person is required to be handcuffed. Now, this direction was there in Karnataka. I think we should also mention it here in this case. So that is why I wanted to see this. And
But here the normal rule is handcuffing.
so that is why it is required. So once this is being made, then we can very well circulate it. So next time it does not happen, because these are the, you've seen the judgment, I've given it to you.
No, the lordship was mentioning that the Karnataka High Court.
This, a copy did you have, look this one. Let both of them go through it. Huh? Copy did you.
Situation is very minor when accused are produced after every 14 days is a routine exercise when the accused are produced.
No, this is very relevant.
They are treated as a cattle in this PI office, my lord. I have seen it in my own eyes.
No, in fact,
Basically, when the heads are counted, my lord, they will make them kneel down in the, what you say, this, inside that, they have a room, my lord, there. They will make them kneel down and they'll count the head. And if any of them, they can come to visit them, no, the roll call is going on. As if in school, my lord, is to see them, and it's
okay, Mr. H. Sharma seeks for an accommodation of 2 weeks for producing the case diary on the next date. List the matter again on 9th of November 2023 at the top of the list.
Number 10 orders.
And shown as part of it.
There are two arguments.
For what?
Number 5 is for confirmation.
Condonation? Condonation for what? Dismiss for default. How many days? Some 3,000, 4,000 days. 248. That is why, otherwise, why will the court fix after 2 weeks? Yes, tell me. And the other one
1 minute, 5 weeks.
for restoration. Okay. Although there is no question of, there is no delay, it's a repetition. The delay does not come in. But what is the explanation for latches? Hmm. Why? Huh? Who was the lawyer? You have mentioned? Who is the lawyer? You have not mentioned. Have you initiated any action against him in the bar council? Then why should we believe you? No, lawyer, today you are not appearing. What you are trying to say, you are pointing a finger upon another colleague of yours, stating that the person has not. Tomorrow you don't appear. Another lawyer says that, look him, this is the person concerned. Did you do it? Did you like it? Whatever reason, why didn't they? He may have informed. How do you show that he has not informed? Because you are, I would have understood 100 days, 200 days, 500 days. This is the case of 6 years. What were you doing all this while? And what was your repetition for? Then, now why are you challenging here? No, because why I'm saying is, why are you challenging now?
Because my lord, the members of the responding number 3 matter. They need to myself. The same building respect to the eviction of the person. I think month of July or August. Then my lord, the petition is whether something happens. Then again, we contacted the appointed lawyer. And nothing is gone. Then obviously was not satisfied. And he appointed another lawyer. And was informed to him that the petition is back in year 2015. The lawyer and for not
It's a fresh call of action. What was your repetition for?
change the operation of
No, that cannot be there. What was the repetition for?
the eviction notice said the petitioner was missing.
Are they again coming out there on the basis of the eviction notice? Same eviction notice? Show me. Where is that notice which has been issued to you? Huh?
To the petition.
Hmm. Huh? No. After that order, show me where is the notice again issued.
You notice it now, you eviction notice after.
Ah. Hmm? Where? No. Why do you say? Let us see what you have stated in your petition. The ADC revenue visited the place, land from where they wanted to evict the imam. When? When? Where? Where have you mentioned in your petition, in your application? No. Why haven't you mentioned of this thing in your petition? Where? See paragraph 2. We dismiss it with cost. I've read it. Where? When? When did these people come? Where? So that affidavit is there?
number 4.
When?
Apparently, what is
What is the date of that affidavit? You see, if you have not taken any action, this court is not going to do it. I'll dismiss this application.
Okay.
Sorry. No, you have not done anything. You have waited for all this. Sorry. I'm not convinced with this.
Then my wait, I'll make this matter. Sometime
Why?
I think will come.
Senior is not here. What can I do? Could he change the view of this court? He can only hear what I dictate. That's all. I'm not going to hear any further. I'm not satisfied unless you have taken any action against him. Why haven't you taken where the person has not? We are not concerned about 100 days, 200 days delay. It is the case of 2000, more than 2000 years. You are at fault. Why haven't you looked into anything? So, why haven't you taken any action against him? If it is the absolutely the fault of the lawyer, why haven't you taken any action against him? Have you lodged a complaint before the Bar Council? If he doesn't want to, then he has to pay. Who is that ADC? Which ADC has gone there? And what is the ADC and what is the cause of action out here? The ADC and Northlok chairman of so-and-so visited the place. For what? Show me your case, a repetition concept. What is your right over a land? What is your right over the land? Huh? 22. Yes, what is your right?
Permission from the construction of the business for restricted project and just do my
You got the construction permission? Where? Where is your permission? Where? I'm coming in 10 minutes. I'm coming in 10 minutes. We do one thing. We restore it and dismiss the writ petition. The very serious allegations have been made.
No. It's on record because he did not appear several times. And all the times I went to.
So the fact that whether you were in contact with him is a question. You are making a statement that you have been in contact and he has been making a statement to the effect that you have misled him, that he had misled you. Isn't that the allegation?
So it is based on affidavit.
No. Whatever may be, this application is not being filed by you. Who has filed this application?
Islam Nawaz.
No, who has filed this application?
Islam Nawaz.
So that is his,
And he has found the affidavit.
so it is his affidavit only. So he has made a statement at paragraph number 2 to the effect, the client has made a statement in paragraph number 2.
So that I stand by. Because his communication, just communicated to us, we have already.
No. I am not on that, Mr. Mamu. Isn't this the affidavit filed by the client? At page 7 of your I,
Not 17.
7.
I said, yeah,
I am concerned with 50580.
I will.
This is an affidavit filed by the person concerned.
Yes.
So under such circumstances, it is not the lawyer who has made this application. So the application has been filed by that person concerned. So he has stated on affidavit making a very serious allegation upon the lawyer. Now, if it is an allegation of such a serious nature upon the lawyer, this does not, if you see the order by which it has been dismissed, this order categorically says that the lawyer did not take any steps against the respondent number 3.
So that is true, but kindly say what the client has stated, that is substantiated by the order of the court. Kindly say one court. One court that is supported by the court's order. Just quickly can.
Yes.
There is no appearance on behalf of the petitioner when the matter is called. On 28/5/2013, the petitioner was directed to the trade steps for service of notice upon the respondent number 3 by Justice Service as well as by registered court with AD by 5630. The petitioner was also directed to file affidavit after making Justice Service as a proof of completion of notice by Justice Service, and the case was placed on 3630 for hearing. It appeared that the case was not listed on 3630 and it was only listed on 11/12/30. However, no step as directed in the order dated 28/5/13 was taken, and on the prayer of Mr. M.K. Rai, learned counsel for the petitioner, this court granted 7 days time to serve notice on respondent number 3 by Justice Service. Office court dated so and so indicate that Justice Service Justice notice for respondent number 3 was made ready, but none had come to receive the same. No step by registered court has been taken in the meantime. Considering the above, the inscription is dismissed for non-distribution. Interim order, if any, service is taken. So his submissions are based on.
No. Subsequent thereto, you have made a specific statement to the effect that when you inquired, he then also said that it was okay.
Yes, that is.
Yeah.
So.
If that is so, it is a very serious allegation. And if you have not filed a bar council complaint, why should this court at all take into account anything?
That will be done, but.
No, if we are not doing that, because this may happen to upon you also. Today, in this, just for example, in this matter, you don't appear. I dismiss for default. Another client out there comes after so many years and say that Mr. Mahmood have been appointed. I called him up and he has informed that the case is still going on.
Correct. That lawyer should be responsible. But here, worship, I may draw your worship attention to our that medicine. And you say that order.
Which one? 1998?
1981. Can you see paragraph 3? The disturbing feature of the case is that under our present at first, there is legal system where the parties generally appear through their advocates. The obligation of the parties is to select his advocate, brief him, pay the fees demanded by him, and then trust the learned advocate to do the rest of the thing. The party may be a villager or may belong to a rural area and may have no knowledge of the country's procedure. After engaging a lawyer, the party may remain supremely confident that the lawyer will look after his interest. At the time of the hearing of the appeal, the personal appearance of the party is not only not required, but hardly useful. Therefore, the party, having done everything in his power to effectively participate in the proceedings, can rest assured that he has neither to go to the High Court to inquire as to what is happening in the High Court with regard to his appeal, nor he is to act as watchdog of the advocate that the letter appears in the matter when it is listed. It is no part of his job. Mr. A.K. Sanghi stated that the practice has grown up in the High Court of Allahabad amongst the lawyers that they remain absent when they do not like a particular case. Maybe we do not know he is better informed in this matter. Ignorance of in this behalf is our bliss. Even if we do not put our seal of immature on the honest practice by discussing this matter, which may discourage such a tendency, would it not bring the justice delivery system into disrepute? What is the result of the party who, having done everything in his power expected to be of him, would suffer because of the report of his advocate? If we reject this appeal, as Mr. A.K. Singhi invited us to do, the only one who would suffer would not be the lawyer who did not appear, but the party whose interest he represented. The problem that agitates us is whether it is proper that the party should suffer for the inaction, deliberate omission or misdemeanor of his agent. The answer obviously is in the negative. Maybe then the learned advocate absented himself deliberately or intentionally. We have no material for ascertaining that aspect of the matter. We say nothing more on that aspect of the matter. However,
But
we are-
Mr. Mahmood,
So
normally it is okay. We take it. But here we are concerned with 6 years of delay. 6 years,
I understand, Lordship.
6 years. 1 year, 2 years is okay. But 6 years of delay means you have never contacted him. When did you last contact him? During those periods.
Yes, that was done. That was done.
There's no statement made out there in your application.
Phase 4 of IA number 58221.
Hmm.
Paragraph 2. The application that the agency definition then after 4 lines. After seeing this by petitioner, a doubt arose that whether the interim order passed earlier by the Honorable High Court has been extended or not. As such, he made a telephonic communication with Mr. Anubhav Sharma, learned counsel on 24/10/21, asking him about the status of his petition, who was appointed as his advocate in this case, to which he says that everything is correct and nothing to be worried about. He was not convinced by his advocate's reply and engaged another advocate of Guwahati High Court to find out the status of his lead petition, and it was learned from him that the lead petition has been already dismissed on 10/15 due to non-appearance of his lawyer on that day. Hereafter, petitioner made communication with his lawyer, but he could not say anything clearly and made an attempt to get clear the consequence of the case. It is also worthy to mention that even after passing the interim order on 25/9/15, the applicant was communicating with his lawyer on several days, and he replied that there is nothing to be worried about, and as the applicant did not know that his case has been dismissed. Thereafter, the applicant has appointed a new lawyer to know the status of his case.
And he informed that the case came up on 10 to 15 and has been dismissed on non-prosecutor. As such, this resolution is fine. So, my lord, in my humble understanding, my lord, the party has done its best. So far, Muslim previous, that is absolutely correct. But my reality is, my lord, I have a vested right here, my property is going to be taken away. So if I fight with my lawyer, my death. So for the timing, the other time, my lord, I remember by showing this judgment, I got a very good order from the court number 2. That was the Krishna Datta Handik's case. The other party said.
So better off, I dismiss it, you get it from court number 1. Doing the same judgment.
That is not my word.
I am not convinced with all
No,
this.
that is not my word. Normally, the coordinate, then decision should be, normally, your lordship is well versed. What I will say. Normally, the decision taken by a coordinate bench should be adopted by other coordinate bench or maybe defer the matter larger bench. That is the maximum of law. Now, my
If it is a law, I'll refer it, but not on basis of facts. This is a question of facts.
question of facts.
This is a question of facts. Are you saying,
Why
no,
facts?
but Mr. Mahmood, no, Mr. Mahmood, are you saying,
Kindly hear me also.
yes,
This delay matter is question of facts and law. both.
are you saying that all cases wherein the client alleges the inaction or the negligence of on the part of the lawyer, then this court should condone? If that is so, it is a question of law. But if you are saying that on these particular facts, the condonation should be done, it is a question of fact.
That I said,
Here, therefore, if it is a question of law, this court will be bound by a judgment of the coordinate bench, but not on a question of fact, which should differ on the what is the fact.
I want to simplify the matter. Kindly convert the matter and or what should do, I will discuss with my client. Definitely we will do something, but at present, either I tell them to take some time, take his advice, whether he is pursuing.
If you don't pursue it, why should I?
No, what this instruction is that at present I cannot say, because normally it's no, I advise the party to find mission against the man.
Okay, now let us hear what is in the writ petition. What is in the writ petition, tell me.
I am not prepared today.
Okay, you prepare it now. I'm taking it in half an hour.
So I'd like you to put up 2 days. Because I have done, I have come 5 years ago. I was studying.
We'll take it up at 2, writ petition, because I may condone the day, but dismiss the writ petition.
Why you are not? If my case is good, why that?
No, that is there. If you have a good case, then it is okay. But if you don't have a case, you have come against some notices. You have come against 3 notices.
Then, so sir, take a view that I will take this decision. Why at present?
Mr. Mahmood, no, Mr. Mahmood, no. Kindly listen. Mr. Mahmood, kindly listen. I've already heard your junior on the question on that writ petition. I'm only asking you, I've already looked into the facts. So here you have come against certain notices. There's no order being passed by which you are to demolish.
For this question I have not done, because only condolence matter I have done.
And that is why, if you remember, the matter when it came up in the last hours of the day on that day, you have said, and I was about to condone, then he said that the delay is 1824 days. That is why I fixed it today on a non-miscellaneous day so that I can take up the writ petition also. Isn't it, Mr. Hendig, you were there?
There is no bar, that is no bar, but today is, we are for.
No, today is not. Today is for everything. You have to decide on that. Unless you have made out the case in the writ petition, then in the case, if nobody is representing the respondent number 3, I will adjourn the matter. Otherwise, no.
That has been, you just start with the practice and then you get back.
We'll see. 2 o'clock. Yes. What is this document?
That is that,
This is for renewal.
for the purpose of, trade license.
No, it is for renewal.
But that is, that must not care for it.
No, this is only for renewal, not for issuance of trade license.
But we are following this process.
No, there has to be some order, but when you are mentioning it to be renewal, why have you given it out there? Because this document categorically says only about renewal. And if it is so for renewal, then there has to be some other orders.
So it's for the. I will not, they are following the process.
Now, how can they follow their process? Tell me. Because if this is the document only for renewal, when you specifically, you should have mentioned it for all trade license shall be given in this manner. There is a reason why it in renewal, it is automatic. And that is ease of doing business. But for applying for a trade license, you need to verify certain documents. You see, clause 2. Also, in the business reform plan, the following forms are prescribed. For renewal of the trade license, no physical manual application to be required for online application. This is only for renewal.
That is the form.
Now, out here, business location address to building permit. So how could you have given out there when it is for residential?
Residential, that is permission. One, master plan of the other project.
Yes, what is it?
Okay. Second thing,
Hmm.
I have marked.
Yes.
Yes, we are not.
No, this is for land use. Land use is different. Are you saying the land use and the building use is same?
One type of town project, one R is there.
Yes.
And it is-
No, understood. Are you saying that the land use and the building use are same? It will have far-reaching consequences. If you want, I can very well put it as your statement. Everybody will be very happy. Then in every commercial area where there is a permission only for use of residential, he can very well open a shop. Commercial. Are you saying that? Then why are you showing me this? Here is a specific case where the building has been only given for residential purpose. Maybe in the surrounding or the vicinity out there, it may be for commercial purpose. Yes, if you see that particular building which is standing out there, it is in an area which is commercial. And in that regard, are you saying that if it is a residential, certain areas which are marked only for land uses for residential, then then also a person concerned would be very well, they can do anything.
That should not be that the things is not at all in terms of the NOC law.
So,
So it is already in violation of.
So-
Residential permission was granted for constructing a residential building lot. But it was not in terms of the NOC law. It's a separate building,
so why do you need the building permit then?
not that. So earlier the NOC was given for construction of 3 apartment buildings.
Understood.
You have already.
Everything is understood, but why in the trade license you require the building permit? See, in your application form. First page, first page. No, the first page. Documents required are business location, address proof, bracket, building permit. Why? So that you are going to see as it whether the building is for residential use or use. How could you have given it when it is not for residential use? It is only for residential. And if this is the format, note, documents required are.
Documents required.
Hmm,
Upload documents.
yes,
First one is upload ID card. ID
no, that
card.
is okay.
The second portion of.
Business location address proof.
Business for building permit.
Hmm. OC. Jamabandi oblique lease agreement,
Yes.
meaning whereby there is an oblique, but otherwise this building permit is required.
Building permission that they, that earlier NOC they have.
Understood, but that is only for residential. Then how could you allow a trade license there? In a residential zone, you can have a trade license. There's no quarrel with that. But in a residential building, you cannot give a trade license. Because otherwise everybody will open shops. We are already seeing everything out there. The entire GNB road is crowded now. It is only in Guwahati you find these type of things. No, it is only in Guwahati you find. Wherever there is any residential houses, immediately there are sprouting of all this thing. That is why all the traffic jams. Hmm? Hmm. Okay, we'll do one thing. We'll finally hear the matter. Anything further?
Only one thing I can subject to your lordship, right? These, what your lordship, what my logic is just now, I think, classification of land use zones. At page 3.
Hmm.
I think this is your lordship's carry.
Hmm.
So if your lordship practice is 13.2,
Hmm.
classification of land use zones.
Hmm.
So now if you see number one residential zone. Now if your lordship kindly 13.3, land use permissibility. Permissibility is that of different land use in the listed land use zones shall be given in table 13.1. So if your lordship kindly see the land use is R. So if you see, this is what you can use it. So number 7 is boarding or lodging houses. There are certain zones like you can use like a pet house or a clubhouse. This is what. So whether on a particular commercial which is residential, can you use it or not as a purpose of boarding or lodging house? Then the lordship has.
No, you cannot. But for that, in fact, that day I passed one judgment in the case of Mr. M.K. Chaudhary. There was a case, Mr. Bora was appearing. It's also a case hereby. This particular building have all along been assessed as a commercial building from 1978. This building was sold by a deed of sale. Thereafter, what happened on 14/11/2020, a permission was given by the GMB for construction. Maybe because earlier there was no permission. Earlier there was a permission which was sold, there was some demolition, and there was another permission, wherein they sought for in that permission ground plus 2. And in that permission, what has happened, they gave the permission for ground plus 1, but only residential. Now what has happened? Being a residential, the FAR becomes less. If it's a commercial, the FAR is more. So the consequences, the consequences would be at a later stage, the GMDA came up and said that you see there, you have constructed more now. You couldn't have done it. And more particularly, it is beyond the approved plan. It is the case of the petitioner. Look here, the construction was done as far back in the year 1997. The permission was given on 14/11/2000, but we have never acted upon. And as such, it shall not be done in that. Now, the question as to whether the permission was granted, which they couldn't deny, that cannot be decided by this court, and this court has to agree. But the fact that it has been all along used as a commercial, it has been assessed from 1978 as commercial. It is in an area which is commercial. I gave a permission for them for the purpose of applying for change in the, not for change, that it should be for making a representation so that the permission can be made for commercial. Because all along the building has been done in there. It will be done now you say, we have that act has come in, the building, what you call Guwahati Building Construction Regulation Act. It has kicked in, and there has been some amendments now in 2022 also. So as per that act, the manner in which they have also a bylaws in which it has to be done. It has to be done in that manner. So that is the judgment which I have given. It may help you out if something is not out.
But what happens, suppose there is a lot of residential area where permission, I apply for residential. But when it is for a commercial, like not commercial, like a clubhouse or a community hall, then what happens?
No, no,
The
no.
Community hall,
You see,
I use it as a community hall. The permission is entire permission residential, then what happens?
no, the thing is like this. The violation is on two counts. One is violation of the NOC,
Yes.
as well as the violation of the approved plan. These are the two aspects on which the violation happens. Now, in the approved plan, it is mentioned where to use how. How are you going to use? If you are having a community hall there, it will be already there.
So there will be no part. That what I.
And if it is being said out there in the NOC, because the NOC as well as the approved plan are both complementary, both goes together. So under such circumstances, if it is given as residential and the community hall is being given, then it will be a residential only for those people in the residence of that flat who will be using it as a community hall. Not, you can't make it as a commercial, asking or giving it for marriage hall.
But your lordship has given a handle in this case earlier also.
That I have given.
Yes, your lordship has
Yeah.
given.
So,
It will not be a part to apply. So accordingly, we will not do anything without the leave of the court.
no, that is what Mr. Kukon had filed an IA.
Yes.
But his IA is a substantive IA, which cannot be decided in this repetition. I therefore rejected the IA and gave him the liberty.
That's what we will apply. We will apply as per the order of this court.
Ah,
They may give or they may not give, they may reject it. Then
that
I
is a
can
different,
offer-
that will be another cause of action.
Then another cause of action of coming.
Yeah. So that is what I told him, that he can very well file a
So
repetition.
only one observation that we will apply before the appropriate authority.
That I have already given in his IA.
Now the situation, now is cancelled. My trade license has also been cancelled.
Trade license is different.
No, I know, I only can't apply on that.
He is number, you are 7, you are the
I'm
tenant,
seven. I am.
you are the builder, but your power of attorney still remains.
No, but that, also I think complete C on that. And now have to go back to owner, so the owner on the back. Now owner doesn't come by, owner is not interested, that's the whole problem. Owner is not interested. If there is some.
Because owner has also given an undertaking.
Now the owner is not interested to come to the court also. That's the whole problem now.
No, but if the owner doesn't come, then it is your thing, because you get your right on the basis of the owner.
But now there is some dispute with the developer and with the owner also.
File
Now
civil
we are-
suit, arbitration, that is not thing for this court to decide all these things.
We will apply before the appropriate authority in my mind, and accordingly, let them take a decision on this.
And that you have already been given liberty, you do. That order is already there, you can very well do. Why should I say any further? Because the moment I say that you can, first you cannot. You are just a tenant. He has no right, but if I say that he can, I will be giving him a right on the basis of an order being passed by this court when there is a dispute between him and the owner, which will have again far-reaching consequences. It will be something like yesterday. There was one matter where an appeal lies against a compensation amount before the district judge. An appeal lies from a, or reference lies from a compensation amount to the district judge. This is as per section 10(6) of 10(3) and 4 of the Telegraph Act. Anyway, this person files a writ. The single judge out there says, no, you go before that competent court under 10(3) and 4. He goes and files a writ appeal. While filing a writ appeal, the court was also not inclined. So the court says there's nothing doing. We are dismissing it. Then he withdraws with liberty to approach the district judge. But what happened? There was a stenographer devil, it became the deputy commissioner. Now, thereupon he applies to the deputy commissioner. Deputy commissioner passes the whole order to the effect he is not entitled. Then in 2000 something, he challenges this writ petition before this court, the order. Now the question is, how do you, all these proceedings have become a nullity. Now say that there is an order passed by the division bench conferring a jurisdiction.
Here also not in the question is whether the tenant is entitled to make an application.
Yes, no, that is why I am not giving, because I am only saying that he can only use it only if there is a change in the permission by the GMC or the GMP.
The application for sale of use also has to be made by the owner of it.
Absolutely. No, owner or even them if there is a power. That is another thing. But I am not going to touch on only all of this, because touching out there would be, I am giving him a right if there is a dispute between him and the owner, which I would not. That is for the civil court to decide or the arbitration to decide. Therefore, in pursuance to the order dated 27/9/2023 passed by this court, the Commissioner of GMC had filed an affidavit through the Joint Commissioner of GMC through one Srimati Loni Borpatra Guhai, who is the Joint Commissioner of the GMC. In the said affidavit, it has been mentioned that the respondent number 7 had in the online mode filed an application for the trade license, and it is on the basis of the said application without carrying out the verifications that said trade license was issued on 3/5/2023. It has been further mentioned that when the said aspect of the matter was brought to the attention of the GMC authorities by an order dated, the said trade license was cancelled on 6/10/2023 with immediate effect. Mr. Nayak, you do one thing, put the paragraphs. This is not the way in which you file your affidavit. No paragraphs. Yeah, so and so. Taking into account the above, it is also seen that the pleadings before this court are complete. Accordingly, this court fixes this matter for final disposal on 7th of December.
There is scope of arguing this matter. I have seen
Where?
scope of arguing this matter.
You get
What
hold
you
of
mean by
that.
use, what is by land use? Just I was going through.
No, that judgment, if you look into it, that's Sufyal Khatun Khan or something. I forgot it. Recently, this judgment has been. Only you may ask Mr. M.K. Chaudhary. He will know.
I know by them orders.
Oh, this is the matter where you are the petitioner. You are,
I'm not hearing from the other, petitioner that is.
okay. So the younger, means the representatives, they don't trust you. Huh? Anyways, we, this substitution, we allow it. Huh? We allow the substitution and, okay. The instant application has been filed by the applicants. Numbers 1, 2, and 3. Stating inter alia that the petitioner number 3, the petitioner number 1.3, that is Ronaldip Chaudhary, expired on 24/6/2023, leaving them as the legal representatives. Taking into account that the right to sue survives upon the said applicants pursuant to the death of late Ronaldip Chaudhary, this court substitutes the applicant's hearing as applicant number as to the accompanying writ petition as writ petitioner number 1.31, 1.32, and 1.33. The applicants are directed to file an amended cause title before the registry forthwith, and on the basis of the order passed by this court, as well as the amended cause title so filed, the registry shall make necessary correction in the records and update in the CS. Main petition. Yes, what is your case? Both are the petitioners here.
How we can get here along?
Yes, come this way. What is your case now?
My plot of lands was taken by the PMC,
I did.
but without any.
I did.
execution and without any award. It was also filed.
Who has taken the matter? Your land has been taken.
Respondent number 6 already filed in the activity of Pera.
Although the land was never acquired by the government, but only requisition in the year 1981. What is the stand of the government? Who has filed this affidavit? Who is respondent number 6, additional deputy commissioner? What will they say? The government stated that the land measuring 6 bighas to be covered by dark number so and so, and we are totaling to 13 bighas of the requisition by Iman for construction of Iman. With regard to the Iman, the land, the report stated the requisition length of Iman, but amounting to Iman was paid to the petitioner for the sale of the land. Yes. Yes.
This affidavit was filed in 2018 also.
And 17/9, there is the order of. They are directed to the instruction.
Yeah, the instruction.
Tomorrow? Or have your GMC is somewhere in Amingo. Let the GMC area. You can't keep there somebody's land like this, acquiring it, repositioning it for 30 years. 81, you have done it. We are in the year 2023, 23 plus another 19, which makes it 41 years. 41 years you have kept this land. Mr. H. Sharma appearing on behalf of the Mrs. P.R. heard Mr. A. Sandilla and Mrs. R. Chaudhary appearing on behalf of the petitioners. Mr. H. Sharma appears on behalf of the respondent number 6 and 7. Mrs. P.R. Mohanto appears on behalf of the respondent number 1. None appears on behalf of the Health and Family Welfare Department, the Finance Department of the Government of Assam, the Director of Medical and Health Services, as well as the Principal of the Guwahati Medical College Hospital. This is a case where, admittedly, the lands of the petitioners were taken on 6/5/1981. It is also an admitted fact that from 6/5/1981 to 34/2000, an amount of rupees 3,99,190 was paid for a plot of land measuring 2 bighas, 10 lechas, being the requisition rank. It is also seen that there were certain steps being taken for issuance of notification under Section 4 of the Land Acquisition Act 1894. But there was no action taken thereupon. Therefore, any acquisition proceedings which were initiated under the Land Acquisition Act had accordingly lapsed by virtue of Section 6 of the Section 6 and Section 11A of the Land Acquisition Act 1894. It further transpires from the affidavit filed on 22nd of February 2018 by the respondent number 6 that the land acquisition process would be initiated as per the provisions of the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013. And further, the requisition rent statement with effect from 1/5/2000 onwards is under consideration. 5 years thereupon, there has been no instructions which are with the council appearing on behalf of the respondent number 1 as well as the respondent number 6. As already mentioned, the other respondents have not chosen to appear. taking into account the above, this matter again on,
Lordship, may I pray on Monday so that I can enact the order of this honorable.
listed again on. Have it on 17th? On. You have the other one? No problem. On 17th of October 2023. Oh, 16th. 16th of October 2023. On which date the councils representing the respondents shall apprise as to what further steps have been taken as regards the land of the petitioners. Mr. Sharma, if you don't take any, you cannot keep the land like this. Requisition is not contemplated for such a long time. And the land value, you cannot keep on thinking like this, that we pay for 20 years only 3,99,000. Now the land and value has to be taken on the basis of the rental value now. I think it will be some 50 rupees per square feet.
Number 12 for hearing.
The top of the list only. Top of the list. Where is the top of the list matters?
Number 13 out of this.
13, 14, 15. There are 4 matters. No. Take the top of the list. 13, 14. There is same no sub 15, 16, 2 sub yes, 13 or 14. 13. Yes, what is your case?
I was granted a settlement for collection of levy
Uh,
over the river Gangadhar. Every national highway, over that, my lord, a work order was issued by respondent number 2 on 19/10/2012. And under that work order, I was directed to pay an bid amount of 2 crore 66 lakhs. It was paid by me over 4 installments. And the work and the period which was mentioned over there was from 21/10/2012 to 20/10/2013 for collection of taxes. However, my lord,
But Mr. Counsel, how can all these things be decided in a writ? How much compensation you are entitled to or not? How does this court decide? How much and you would have been able to collect? Should we put it at a nominal figure of ₹2?
my lord, we have the clause out here in the bid document already. The terms and conditions of the bid document, my lord, may come to page number 36.
30?
36.
Yes.
Clause 15. Here it was mentioned, the industry will not be allowed any claim, any compensation or emission of the bill money on account of any temporary closure of traffic to the bridge for a continuous period not exceeding 15 days due to any damage of the bridge and road means for natural calamities like food.
Wait, clause 15, the lessee will not be allowed any claim, any compensation, any claim, any compensation or remission of bid money on account of any temporary closure of the traffic through the bridge for a continuous period not exceeding 15 days due to any damage of the bridge and we have for natural calamity. Yes, then?
Yes, my lord. After that, what happened during the period from 21/10/2012 to 20/10/2013, when the work order was issued to me for that period. During that period, a total burn, Assam burn of 114 days was there. As per the statement of the SPB, which can be find at page number 18 of the requisition, whereby the SP has clearly stated that 114 days of burn was operating at that point, at that period of time. So, my lord, the thing is that the work order was issued for 365 days. But however,
Your work order was from?
my work order was from 21/10/2012 to 20/10/2013.
21/12/2010
21/10.
21/10/2012,
to
12.
2010,
huh? 20,
2010, 2013,
2015, 1 year.
1 year.
And
My lord, during this period, 140 days one was operating.
with a fifth. Huh? Wait. Yours were from 21/10/2012,
To 2010, 2013.
2010/2013. This is it.
Right.
Okay.
And during this period, one was operating for 114 days in the Hubli district, my lord.
How do you say so?
My lord may come to page number 19.
Hmm.
Here the
List of bond programs shocked by various organizations with effect from 2010/2013.
my lord, but then you can, my lord, may peruse the statement which was been given.
Hmm.
It started from 9/11/2012.
Hmm. Then,
And then, my lord, during this period, my lord may come to page number 20,
hmm,
whereby
114 days.
there was an Assam one on 5/8/2013,
Hmm.
whereby the United Democratic People's
Okay, now I've understood it. This is 114 days. Now, what is your case? This 114 days remission you are entitled to.
My lord,
How much?
my lord, the total amount is calculated for
By?
because 2,66 lakhs was deposited by the petitioner. And further, an extension of 3 months was also given, right, for the number 2, whereby another 72,07,507 rupees was deposited by the petitioner.
No, but how does this court come to a finding that you are entitled to?
My lord, the
Isn't it a purely a civil dispute? The loss which has been occasioned, how much you would have gained every month, every day, if all these days you were there, how would you have got it? How can this court decide? Except remitting the matter back to the authorities.
My lord, if my permits that reading the matter back to the authorities, then that is possible. Because the thing is that earlier restitution was filed.
Show me the impugned order.
Based on page number 45 of the lecture 9.
55, yes. With reference to it has been informed that Assam one was for 56 days as per the copy of demand, dated demand. Further, it is to mention that the vehicles were plied on police escort during the as also was granted extension for a period of 90 days from imminent. Then, what is wrong?
My lord, the thing
This is another document.
another document was given by.
This seems to be the correct document.
My lord, another document was given by SP Dubri, whereby.
It is 56 days.
My lord, you mentioned 1,500 hours that was Assam Band during that period. You mentioned it as 3 days. Now, when it comes to a logical conclusion, my lord, 1,500 hours cannot be 3 days for that period of time.
Hmm.
There's discrepancy in the first report and in the second report as well.
Why?
Because in the first report, that is at page number 20, my lord. Here he mentioned, the SP Dubri mentioned 1,500 hours as 50 days, 50. But in the next report, which was given by him, here he mentioned 1,500 hours as 3 days.
It should be 150. What is this 1,500 hours?
1,500 hours was the bund that was operating as 50 during that period of time.
So how much is 1,500 hours?
1,500 hours comes up to approximately 62.5 days.
Then why is he given 50 days in a year? And how can he give only 5/8?
Exactly, my lord, that's the point out there.
Yeah.
There was discrepancy in both the reports.
Then, and how can this court decide?
So, my lord, the respondent relied on this particular statement, and then they gave a view that I am not allowed to get remission or claim for that matter. My lord,
Rightly so. And you should have gone before a civil court. You should have proved, yes, these bonds were there or not. Then, how can this court do all these things?
my lord, the respondents are directed to submit an instruction of that matter, whether
But they have filed affidavit.
they file an affidavit, my lord.
What do they say? Is there a bunch during the period from so and so is actually 56 days in a year. In this regard, so and so, respondent communicated to the specified that there are 56 days of burn declared by the various organizations. It is stated the vehicles also plied during this period. So
But they were applied through police escort, my
So-
lord.
the operation of the toll gate was only about 69% of the total period of so and so. That the total of is also not correct. In fact, the letter dated of the Eastern so and so clearly the traffic movement was not stopped altogether, but restricted to the single lane one way only, and there was no reduction of traffic value. So these are all disputed questions or facts. Can't help it.
I've never tried to call the director.
Direction for what?
The respondents, the director, give a clear picture of what has been going on.
What they have already stated. What additional things do you require?
Why not? Because there are discrepancy in both.
So- If there is a discrepancy in both the reports, so it is better for you to prove it before the civil court. You have not done it. And how do you extend the period of limitation?
I don't think it's a pending for.
So, How can this court decide?
That my lord, there was a writ appeal against earlier decision as well, whereby the honorable division bench, they directed the petitioner, the current petitioner, to go before the respondents and file a representation for remission. And consider, and the respondents were directed to consider the case as per according to the law. My lord, then the petitioner is submitted a representation.
Now you want similar types. A similar direction.
The particular direction might be,
Isn't it the same thing which has happened earlier?
because my lord, the petitioner.
So every time I will get this court, whenever it comes, I send it back and then they keep on deciding. And then again you file, this will be a non-ending matter.
So the petitioner, my lord, he is literally broke bankrupt as of now. He has no money left and now he has the.
No,
he has come for this court.
Mr. Counsel, I think you are appearing before this court for the first time. This court has no heart into all these sympathies. I don't have any sympathy on these things. My thing is simple. You make out a case of I'm not on the, what has happened, he is bankrupt or not, that is his lookout. But the fact is, these are disputed questions of facts. One person says this, the other person says this. You say that you have not been able to work on 114 days. The other fellow says it is 56 days. Even if during those 56 days also the cars were moving. This is their stand. Then how come this court decide as to whether he's right or wrong? This court has to come to an opinion that yes, it is wrong. Can this court decide? No.
I know in that case, the petitioner can go to the civil court, but then limitation can be based on my lord. My lord agrees.
Chalo, I think that is the best option. The instant petition was filed by the petitioner. Has been filed by the petitioner. Challenging the communication of the letter bearing number NHC 243/2013/14 dated 28 March 2014, as well as seeking a direction upon the respondents to grant compensation or remission of the bid money to the petitioner to compensate the loss suffered by him on account of non-collection of toll/levy in respect of Gangadhar Bridge on NH 31, District Dhubri, due to local and state-wise burn that occurred during the period of settlement of the same from 21/10/2012 to 20/10/2013. The facts involved in the instant writ petition, as to be discernible from the pleadings, is that the petitioner was settled was granted a settlement for collection of levy in respect of Gangadhar Bridge, bracket B Silaroi Dolong, bracket close, over river Gangadhar on NH 31 under Abhayapuri NH division in the Dhubri district for the period from 2021-10-2012 to 2010-2013. The petitioner quoted at a bid value of rupees 2 crores 66 lakhs. It is the case of the petitioner that during the period from 21-10-2012 to 2010-2013, there were several bunds, both local as well as the statewide bund, which had affected his settlement operation. It has been mentioned that on the basis of a document issued by the Superintendent of Police Dhubri, dated 15/9/2013, that the total bund period for this bund period was 114 days. Although the said document, which had been enclosed as Annexure 2 to the writ petition, contains the heading of the list of programs chalked by various organizations with effect from 2010-2013 bracket 2012 bracket 2010-2012 bracket till date. But the period mentioned therein is from 9/11/2012 to 28th of August 2013. And the said document was signed on 15/9/2013. On the basis of the same, the petitioner sought for remission of granting of compensation to the petitioner by the respondent authorities. On the basis of the payment which was made by the petitioner. It further reveals from the records that there has been an earlier round of litigation whereby the petitioner had filed a petition being WPC number 6985/2013 and had sought for remission of grant of compensation. However, the said respondents have refused to grant that compensation to the petitioner, for which the petitioner had earlier approached this court by filing a writ petition being WPC number 6985/2013. The said writ petition was disposed of by an order dated 10/1/2014. It is, however, relevant to take note of that in the said petition, the petitioner sought for a further extension to the extension which was already granted by the respondent authorities. This court, by the order dated 10/1/2014, did not grant any extension to the petitioner, and rather permitted the respondent authorities to finalize the tender process that has been initiated. It further reveals that the petitioner thereupon prepared a writ appeal before this court, which was registered and numbered as WA number 22/2014. In the same writ appeal, it was the case of the petitioner that the petitioner be permitted to claim remission from the department as per the terms of the contract, the division bench of this court, by their order dated 30/1/2014, permitted the petitioner to approach the department for remission, in which event the department was directed to consider the application and pass order in accordance with law. The record further reveals that by an order dated 28/3/2014, the chief engineer PWD and its works observed that the bunch during that period was 56 days. On the basis of a letter from the Superintendent of Police Dhubri, dated 23/2014. And further, it was also mentioned that the vehicles were plied on police escort during the said Assam Bandh period. It was further mentioned that the department has already granted REMI extension for a period of 90 days. That is from 21st of October 2013 to 28th of January 2014. It is under such circumstances, as the respondents have refused to grant remission, the petitioner has approached this court seeking the reliefs as above mentioned. The record further reveals that an affidavit in opposition has been filed by the respondent number 2, that is, who is the chief engineer PWD and its works. In the same affidavit in opposition, it was mentioned that as per the foreman work order dated 19/10/2012, the settlement period was from 21/10/2012 to 20/10/2013. It was mentioned that the work order did not specify as to the number of days the said toll gate should be operated. It was further mentioned that the Superintendent of Police, DSB Dhubri, had, during the same period, had mentioned that during the period of settlement, that is from 21/10/2012 to 20/10/2013, there were 56 days and not 114 days of bunds. It was also mentioned that the vehicles also plied during this period. Apart from that, it was the respondent number 2 in its affidavit stated that the operation of the toll gate for only about 69% of the total period of settlement is not correct. No. Further stated that the total number of bunds, stated that as per the letter dated 17/9/2012 of the Assistant Executive Engineer PWD, Golagganj NH subdivision, the traffic movement was not stopped altogether, but restricted to single lane, one way only, and there was no reduction of traffic volume. It was therefore stated that the question in the facts of the case, the petitioner was not entitled to any remission. To the said affidavit in opposition filed by the respondent number 2, the petitioner also filed an affidavit in reply, denying the contents of the said affidavit in opposition. I've heard the learned counsels for the parties and also have duly taken note of the pleadings as well as the materials placed before this court. The question which arises for consideration is as to whether the petitioner is entitled to any remission of late compensation on account of the bonds inasmuch as on account of the bonds which the petitioner on which dates the petitioner claims that there was no flying of vehicles during that period. There was no or very less flying of vehicles during this period for which the petitioner sustained loss. On the other hand, the specific stand of the respondents is that though there were 56 days of burn, but vehicles were flying through escorts. It was also mentioned that there was no reduction in the volume of traffic. The above aspects of the matter clearly shows that these are purely questions of facts, more particularly purely questions of facts, which requires adjudication. For example, with a weeds, the question as to whether as to how many days the bunds were operating, semicolon. The question as to how much loss the petitioner sustained on account of the bunds. The question as to whether the vehicles were allowed to fly during the bunds through police escort. The question as regards whether there has been any lessening of the volume on account of bunds, and to what extent. These questions of facts cannot be decided under Article 2 to 6 of the Constitution. In that view of the matter, this court, therefore, dismisses the instant petition on the question of maintainability. This court, however, also, next one, be that as it may, this court, however, finds it relevant to take note of that the petitioner has been diligently and with a bona fide belief have been pursuing the instant petition before the court, pursuing the remedy before the court, and taking into account that on the ground of maintainability, the instant petition has been dismissed. It is the opinion of this court that the petitioner should be granted the benefit under section, limitation under which section? 5. 5. What section? Under section 14 of the Limitation Act 1963. For the period with effect from 16/7/2014 till date, that is alleged. While computing the period of limitation, the petitioner would be well advised to approach maybe advised to approach the competent civil court. Now, the petitioner would be at liberty to approach the competent civil court, and the dismissal of the petition shall not prejudice the rights of the petitioner.
but whether we consider for the remaining period and whether he has the right for it. I assumption that if there's a right for the unexpired period, the contract, and thereafter, my lord, since would be a licensing, but you would have a right for consideration for this.
Then it will be violating 19(4).
But it is in terms of the contract, but I rely upon of the judgment because of the
No, no, which judgment?
interpreting similar
Show me. By?
by only just Naveen Chawla. There was a dispute regarding similar issue that was taken to arbitration. And
Yes.
that comes to letter 7.
Yes.
There's a reference for the unexpired, the reference because the reference of completion of this, the name of first substituted for the name of transfer for proprietor of currency. Therefore, environment was also been referred. So they were required to execute it. Now, on expiry of the original period of license, the petitioner first offered extension of license. The however withdrew such offer on the premise that the respondent was not entitled to seek renewal extension of license.
Where you are on expiry, paragraph 8. The license petitioner first offered extension of the license, however, withdrew such offer on the premises that the respondent was not entitled to seek renewal extension as a legal heir of the owner. Then
9 months. The respondent herein sought extension of the license awarded for a further period of 5 years. Dispute arose between the parties over the interpretation of the term unexpired period of the license. As it was contended by the petitioner that the respondent had been granted a limited license by way of the transfer of license allotted to the firm.
Then?
Para 14 minutes. Who has to enter the term, or by the improvement of para 14 minutes. The arbitrator given his detailed finding on the execution in the party, the relevant findings of considering all factors involved in the process, the tribunal is of the view that the occurrence of three device cannot be used to describe and legally correct and technical right. Also, the definition of license as defined in the agreement unquestionably also covers such eventuality. The license's right to be considered for renewal of the licenses cannot be taken away merely because the individual involved is a legal heir of an original license. After all, it has taken the full mental form and shape of the license and approved by the respondent. The fact remains that Mrs. Mayuri Main's contract have not been considered for renewal for second term of 5 years. Only on this ground, as IRCTC has taken unexpired period to mean the first term of 5 years only and not beyond it. It has assumed that such a transferee license is ineligible for renewal for second term of 5 years. The tribunal considered that the stance taken runs against the definition of licensing enunciated in the document section. It has also been noted by the tribunal from the official notice in that. Next page, Your Honor. But the committee was well aware and recorded that the license is further renewed for a period of 5 years as per the document. However, it cited and relied upon the transport clause contained in the catering policy. Similar clause. It was also aware that the IRCTC had assumed the name of Mansoor to be substituted for the name of Chief Mansoor as the proprietor for the unexpired period of the license. However, it defaulted in not recognizing the right vested in the licensee, nor did the approving authority raise any query on the recommendation of the committee. In tribunal view, the authorities concerned have not applied their mind for the application of legal and administrative property extra, etc. While it will need to grant renewal for second time despite its performance of remaining ceremony. Now, para 15. Main dispute between the parties is whether the respondent has a right to be considered for the renewal of license. It is the submission of the learned counsel for the petitioner. That as the respondent has been granted license and therefore only for the unexpired period of license, he was not entitled to be considered for renewal of the license. In this regard, the learned counsel of the petitioner places reliance on the above quoted letter dated so and so issued by the petitioner to the respondent communicating the approval of the completed document, the substitution of respondent's name in place of husband for the unexpired period of respective license. Let it come to further relied upon the clarification dated 2/9/2008 received by the petitioner from the Railway Board, Ministry of Justice, reproduced herein below. It is reiterated that transfer of license is permitted in the case of death to the legal heir of the licensee for the balance period of the agreement. There is no provision in the exchange policy for further renewal of the license to the legal heirs of the license after the expiry of the agreement. The same stand has been taken herein by the respondent. Well, putting this all this further matter. Now kindly come to para 29.
Yes, I read the judgment.
Reading of the above provision would at a renewal of license for a second term of 5 years for provided subject satisfactory performance of the license. In the end, only financial obligation of the licensee for extent was a minimum 10% in prevailing license. Because evidence from the document as a 50% of provision. The above provision would therefore show that there was no automatic renewal of the license. The respondent was to be considered upon request for renewal of license on the basis of satisfactory performance of the license. In the initial payment, the tenure of all licenses or renewal of the purpose is the depth or period of 5 years. Therefore, the provision of technical or data moving that the substitution is for unexpired period of the license. They have no hearing so far as the consideration of the licensee for the renewal of license is concerned. The respondent therefore has the legal heir of the licensee upon being substituted for a disease judgment for the unexpired period of the license. Take the license for the unexpired period initially. And also be entitled for consideration for the renewal. Expiry of the insurance of 5 years. The interpretation of battery policy to cover the renewal is incorrect and it will rightly rejected by the administration. See the agreement also, my lord.
Mr. Dubey, that is a judgment in a proceedings under 34. In a proceedings under 34, the court's power is very circumscribed.
Right.
And being so, when an interpretation is given by the arbitrator, the court, unless it violates the public policy, would not. And when there is an arbitration clause, the interpretation of the terms would be as decided by the arbitrator. Absolutely. So it is under such circumstances, the question of interference or not to interfere was before the court. How can you apply the same facts here, where the question is, am I bound by the arbitrator's award? Here, no. Because here I am exercising 226. So how is that judgment going to help you?
My successful assumption for your consider. But this is one possible view of the interpretation of unexpected.
No, if it is one possible view is not the question.
For me, it's the only possible view. But if your office takes another view of the matter, then also there are two possibilities. And one possibility will go in favor of the petitioner, because it's also in light of the contract.
Where is the contract? What does the contract say? Contract only gives the right upon them unless you serve. Because the contract categorically, if we go by the contract, it does not say anything. 3.2 is only as regards the person concerned. He has a right to be considered for further renewal. He has a right to be considered for further. That's all. Now, 2017 policy, in my opinion, would not hold the field because this was entered into in spite of the 2017 policy had come in, which they ought not to have entered into, but then also they have given a clear go-by to the catering policy of 2017. Page 62. Yes. Yes.
They have given benefits in any other life.
Because you have come at a time when, on account of COVID restrictions and all, you could not submit the succession certificate. That is what I could see from these documents. So that is the reason why you have come. Now you have the succession certificate.
They're not disputing my legal.
So the question is, can you be beyond that? Because whether 19.4 or whether clause 3 would override 19.4, wherein it is said only as regards the unexpired period. If it is said so,
The same terminology was.
understood, that is for the arbitrator. I'm not concerned what the arbitrator says. We are not in arbitration. You want to go for arbitration, there is a policy out there. You want to go for arbitration, go for arbitration. That is your lookout. The catering policy of 2017 has an arbitration. Go there. And you may get a similar decision out there. But what to do with 19.4, wherein it is specifically mentions only for the unexpired period?
But once, Malad, I come into the school of the licensing mother.
Then it would have been clearly mentioned that this should be only for this period, or you would have the same rights.
Then
Just for example, if you see the other clause out here, the assignment, this is very relevant, 19.9. The agreement is binding on the successors and permitted assigns of each party. However, neither party has the power to assign this agreement without the prior consent of the other party. Now kindly see 19.5. In case of old age, disability, infirmity, chief commercial in exceptional cases only may personally consider request of individual license for inclusion of the name of their son so-and-so, subject to his or her performance being satisfactory, and also that no railway dues are pending against the licensee. Railway will also ensure that the son whose name is proposed to be included in the list does not hold any other catering license of so-and-so. This is during the lifetime. Because here, Mr. Dubey, this is a case of state largesse. This is a case of state largesse. No, wheelbarrow, no wheelbarrow, pistol, whatever may be, this is a case of state largesse. Can there be any, beyond that agreement, can there be any other right?
see, rightly or wrongly, they have also relied upon the effect for judgment of.
Who? Where? Show me.
In 19,
Yes.
clause C, whereas division pursuant to letter of judgment and on the basis of the judgment delivered for provision of capital.
Now that is why, Mr. Dubey, there is no quarrel with the proposition that you are bound here by the 2010 catering policy, because they themselves have given a go by to the 17 policy by having clause 3. So there is no quarrel with that. But the fact is, therefore I'm saying you will be bound by the agreement, not by the catering policy. But if the agreement says only for the unexpired period,
There is a requirement of by that this gives me a right for the unexpired period and for the license, and which is a matter of right. And now, Lord, for the next period, Lord, there is a right for consideration. These two rights are. And Lord, from 2017 onwards, in terms of the catering policy, Lord, they have closed the scope for wheelbarrow. Lord.
Then,
Lord, whatever that continues, it continues for the unexpired period. Because I am a poor man, Lord. I have no other.
there's no poor man, rich man. I don't go by poor man, rich man.
2016 judgment. Lord.
That is for Supreme Court. Supreme Court of 142 can do many things. I cannot. And recently, the Supreme Court even says that the 142 exercise cannot be made in against the statute.
No, madam. I am not, but only the objective matter. I mean, they would have considered not what the, they have tender blood for all other things, but not Rivero. They would have considered my responsibility, right, blood in terms of that and allowed me, but it doesn't make any them. So the three processes are.
No, does not have a difference for them is not the question. This court cannot have only a side to that effect that whether the railways have done it rightly or wrongly to that effect is not the question. The court also has to take note of that this is a case of a state largesse. And the state largesse can be given to you. Now you have a catering policy of 2017, which do not permit any renewal. So under such circumstances, you normally would have come under the catering policy, save and accept the agreement. Now, if the agreement says your entitlement only in terms with that unexpired period, how can you go beyond that? That is the only question. Because are you not blocking somebody else's rights?
No, madam.
Why?
So,
Somebody else cannot get the wheelbarrow?
no, because they have, they are not issuing any license for wheelbarrow.
So then the matter ends
So, Lord, therefore, Lord, my prayer, Lord.
that you will go, if they are not having any license, this court should form up a policy for that.
No, I'm not asking for a policy. I'm asking for in terms of the contract only, but let them consider my case for wheelbarrow for the limited period because thereafter.
Limited period means after the death,
Yes,
or for that unexpired period where you could not run.
unexpired period, then my.
You may make a submission that the unexpired period will be for the period during which you could not run.
My Lord. And thereafter, let them consider for renewal, for consideration, my Lord. It's not that I'm claiming as a matter of right.
No. That will again start another Pandora's box. If you go by this, because you see, then this court will be going against this. If I give you this right under 3, which yes, your father would have been entitled to, but whether if I give you this right, would I not be saying that the unexpired period would mean that only for that he will step into the shoes and thereafter he'll become the licensee?
Yes,
In other words, what you are trying to say?
I would become a licensing, Lord, because that is my right.
Your licensee is only for,
What clause, Lord, they will incorporate, they will put in the shoes of the licensee of the same agreement.
Hmm.
The moment I become a licensee, I have a right for consideration. Otherwise, they cannot write a different contract for me.
no, then what is the meaning of having it only for the unexpired period?
Because they cannot foresee at the time of entering, they cannot say that I'll give you a right for consideration for, my lord, I will give you a renewal.
So you mean to say, once you step in there,
My lord.
at that point of time, the concept of giving a renewal does not arise. Renewal is subject to consideration. Even the main licensee also did not have a right of consideration, did not have a right of renewal, automatic. It was subject to consideration. And as such, it was limited only to unexpired.
I'm of that.
That is what your submission. Yes, ma'am.
Error 2G, that case speaks of identity of the person. a not case of the renewal of, extension of the tenure of the license. This is a case of transfer of license to the legal head of the business. So already railways denied because they did not, they failed to submit the document evidence as, moreover, the submit any document evidence regarding the name of the legal head at the time of execution of the agreement. So, in para B, in view of the background, the petitioner is not entitled for transfer of license of the original licensee in his name without any authenticate document evidence under the Category Policy 2010. Railway rules as explained in the above letter dated 27/7/2020 and official letter dated 9/9/2020 as is not fulfilling the actual requirement in this regard. In fact, the instant contract agreement was executed in terms of Catering Policy 2010, which was superseded by Catering Policy 2017, which is specifically about the renewal of the such mandate unit. Hence, question of renewal of such mandate unit does not arise. However, after expiry of the state contract agreement dated 5/9/2018, Railway has taken back the physical custody of the state unit. It is important to mention here is that by the notification dated 27/2001, Railway license is plotted the tender for licensing general minor units as referred to NSR 9 page 67-71 of the decision. As per above mentioned notification, dated 12 to catering handling units emerged for women, men, or hybrid mission where is the stall like the present that is not included. As the above notification is neither illegal nor illegal nor malpractice. But I think it is important to mention here that the application for the petitioner was not considered as per para 21 of the.
Where is the catering policy of 2010?
20.
Yeah. Transfer of license to the spouse would be allowed only in the event of the land can be transferred in the name of the spouse for the unexpired period of the agreement only with the personal approval of so and so. The nomination should be only from amongst the family members. Renewal of license on transfer to legal heir may be permitted only in case the licensee belong to reserved minor catering units as per it. No. Kindly see the last line of clause 21. Page 20 of your renewal of a license on transfer to the legal heir may be permitted only in case of licenses belonging to reserved minor catering units as per existing instruction. What is this reserved minor catering units?
Only for the next, handicap or women, whether some reserved units.
No. Belonging to reserved minor catering units. What do you mean by reserved as per existing instruction?
Only for one woman and handicap.
How do you say so? Reserved minor catering.
That minor unit is the individual farm company which is allocated to hold maximum minor catering unit at this station and a maximum of 10 units per donor revenue. In case of
Where are you reading from?
catering policy, there are 19.2, 10, catering policy 10. From there.
19.10.
There are 19.2 minor units. And other units.
19.2 I don't have. Continue.
then it's also given the authority.
An individual farmer will be allowed to hold maximum 2 minor category units at a station and maximum 10 units per month. In case of suburban section, ceiling limit of 2 will be applicable. So what is reserved?
There are 15 of the Supreme Court of 2010. There are 15 reserved in allotment. 15 reservation in allotment.
Ah, there should be no reservation for major units. There should be 25% minor.
There should be 20% reservation for minor units in a category station with the following breakup.
Or you belong to any of these? Scheduled caste, scheduled tribe, poverty, people below poverty line,
Minor, yes.
freedom fighters, other backward classes, minorities.
No, because it is pilot.
No, then
Now she rejecting ideas pilot, but that's when it was evidence for application of this solution.
so only for those reserved people they will get.
Yes, fine. Okay. That,
So thereby, that clause of 21 specifically therefore ends the period after the expired period, and the renewal would only be permissible in respect to reserved.
since the system is not belong to the reserve category, so it's not entitled for the
So renewal is not permissible.
moreover in Act, but in Supreme Court 2017, there's no any provision for renewal of the constitution.
No, because we cannot go by 2017 because you yourself have said that you have, or you have even given a go by, because you entered into an agreement in 2018 by following the scattering policy of 2010. Because because your license is from 2015.
Yes.
But what do you say? Oh, he could not submit within that period which ended, no? By 31/10/2020, he could not submit.
Already from the-
You are running still. Oh, he has already taken over, na?
Already taken the custody of the window.
That nomination of the legal heir could be obtained from the license at the time of entering into the contract. So the burden is on them. They also have taken the nomination.
Forget about the nomination.
But they have rejected on the ground, not that whether I am a minor or I belong to this. They say unexpired period, you don't.
No. Your right to renewal
Minor.
would only accrue if it belongs to a reserved minority unit.
That
Otherwise, you are not.
I understand.
No, therefore, clause 21, if it is read with clause 19.4, makes it, clause 21 makes it clear that otherwise there is no question of renewal. The renewal will only come when there is a, you belong to the reserved minority.
That issue has never been asked for, but that we belong to.
Now they're asking me, no, none of it is I who have seen it. They have also not taken that ground. Have you taken? No.
That was not part of consideration at all.
From the letter.
That is not a part, mean they have, the thing is that it had ended. They have vaguely said 21. So 21 will include everything.
And there's a blanket no that you don't have. Now that relying upon this law, at least it gives some semblance of right, at least to persons who are in this category. Now, they have also not asked whether to govern. So that can be done by them only, but
You are in reserve category.
I belong to this minor.
No, we'll do one thing.
My letter can be relying on the annexer 8/62, the decision of the government of Indian Railway.
Where?
8/62 of the decision.
Oh, that I have seen it.
Para C,
Where it is said that if they fulfill all the documents they are given.
they are not entitled for any transfer of license or renewal of license as they claim. Then one of the provisional public conflict agreement under clause 19.4 to be frustrated and the clause 20, para 21 of the. The question of record also. But if they take the effort for the administration. So they have to the court, challenging the non-giving of the non-transfer of their license. So their provisions of the contract agreement here, 19.4, is the first of it. So, they have accepted this agreement. Now they are on the basis of clause 19.4, they have no any local standing, no right to claim the transfer of license after that unaccepted. And if you are not understood, or any advantage from the
Now you have stopped wheelbarrow.
yes, madam. Because if you are already you will be allowed to take under consideration.
So now you don't have wheelbarrow.
Don't hurry.
And both are wheelbarrow.
No, money is a misleading statement. In case of Wilbur, they have written the case stop, which is in the record of the railway, madam. Already I mentioned in my editing of person in Canada.
Page 74. Page 74, page 5 of your affidavit. Last paragraphs in italics.
Yes, madam. So, cannot be the issue of Krishna regarding for license in his name after death of his father is in complete violation of the claim policy 2010 and for 19.4 of the agreement with the Cabinet 2018, which is to pay illegal and business. Moreover, this state established or provide any evidence for such a claim in the event of father's death on 19/2019, who are already licensed during the answer period of agreement. It will be noted that the original contract agreement was expired on 31/10/2020, that is after date of the original licensing. But the petitioner claims the transfer of license on 6/9/2019 in his bill is violation of the para 21 of the Secretary Policy 2010, dated 27/7/2010, and clause 19.4 of the agreement dated 5/9/2018, which clearly spell out that license can be transferred in the name of spouse legator of the unaffected period of the agreement in the event date of the original licensee. The petitioner takes to establish this place as a legal head of the original licensee of authentically with any legal documentary evidence as referred under the Secretary Policy 2010, which is evident from the office letter dated 27/7/2020. As referred to annex of 5 and page 59 of the institution. It is not that the dated 3/8/2020 as referred to system page 60 of the institution. Already I clearly mentioned, they fail to submit a documentary evidence. Moreover, the original license returns clear the name of the spouse or any legal heir at the time of entering into contract with the respondent. In fact, the first Indian license in the name of the late Premchand Shah was done for the period from 1/11/2015 to 31/10/2020 as per the Secretary Policy 2010. And the same was operated as per agreement dated 5/9/2018. And when he paid up to 2020. In such position, neither question and execution of Secretary Policy 2017 or violation of the clause 15 of Secretary Policy 2017 in this case arise with the respect to protection. I already mentioned that they are claiming as a key stall, but railway also considered that the claiming transfer of license in the name of the town by mentioning key stall, Halakata instead of wheelbarrow, which was a misleading statement without any documentation. And was not given to accept them, thus saying.
This was given when?
In September 2020.
Huh?
September 2020.
And when did your father expire?
No.
Then, but that is as per 19.5. Then what happened?
They also not considered.
Then again,
Then, 30th, just one day, because he expired on 10/10, my lord. That date. Luckily, he could make his application on 30th of October, a day prior to expiry.
then what is this page? What is this page 58? One can't read.
The tea stall,
Tea stall of so and
it's their own letter, my lord.
in reference to your letter under humanities under para 18 of the Gateway policy, which is transfer of license will be allowed only in the event of death of the owner. The license shall be transferred to name of the legal heir for the unexpired period of the month. As per the agreement of the month, 31st of the return and such a deed, dated swings for the question of transferring the license to the legal heir of the unexpired. Okay,
And his subject is dated tea stall.
so which one of your tea stall you were in page 59 and 60 and 61?
One tea stall.
Which one?
There was only one tea stall at that point of time.
Which one? In this this particular LIT?
Particular two tea stalls they have, we don't know.
Where? We are concerned with which one? Your that platform is not here,
Serial number 2,
Falakata.
Yes.
One tea stall. Did you participate?
no,
Why?
My lord, case 60 of the system.
Oh, another important thing. DEF, this category is D. The persons who comes within the reserve category is scheduled caste, scheduled tribes, other backward class and minorities. In A, B and C, there are many more. So D only 3-4 people. And there is Falakata is only one tea stall. Where is wheelbarrow?
these were then excluded because they are not continuing.
So tea stall number 1.
Yes,
My lord, there was not, the original license was not running at this story for wheelbarrow. Because it is evident from this letter, dated 3 in 2020. We issued to the
Where?
at 360 and it's a 6 of restriction.
Page 60 is something else.
But no matter.
Which petition? Your own letter says something else. You made a mistake. You kindly see, this is for transfer of tea stall. At page 57, on the basis of the license agreement, so and so have been extended from time to time. The last agreement was executed with my father dated a month for the period from so and so. During the council, my father became ill and so and so. Being the son. Here also he has written tea stall. Your license, you have also mentioned it as tea stall. Kindly come to page 58, the document which only Mr. Dubey can read. And Mr. Dubey may read it aloud. Yours is better. For me, it is not to be seen. It can't be read. For good reasons. Yes,
That would
obviously.
be a wrong,
This imputation goes to Mr. Dubey only. Yeah, this document says tea stall of late so and so. That is your document. Why you are saying that wheelbarrow and all these things?
Find out the second stall. Serial number 30. Snack bar.
Huh?
Serial number 30.
This snack bar.
Yes.
No, you are not good snack bar.
I'm tea stall.
You are tea stall.
Pistol is there.
No, that is for women. Hello, enough. Let me dictate. এটা লিখি দিছো ইটো একে কৰি দিম হা মই ক'ত ক'ত চেঞ্জ হ'ব মোক কৈ দিম The instant writ petition has been filed by the petitioner seeking a direction, seeking a writ in the nature of sorcery for setting aside the communication dated 9/9/2020 issued by the respondent number 4, as well as the impugned tender notice dated 2/7/2021 to the extent it includes the tea stall of the petitioner at platform number 1 of Falakata railway station. The petitioner have also sought for a writ in the nature of mandamus directing the respondent authorities not to give effect to the impugned letter dated 9/9/2020, as well as the impugned tender notice dated 2/7/2021 to the extent it includes a snack bar. Where do you come again? The snack bar comes in. You are a wheelbarrow. In place of the wheelbarrow of the petitioner at platform number 1 of Falakata railway station. And further, a direction upon the respondents for transferring the license for the wheelbarrow at platform number 1 of Falakata railway station in the name of the petitioner. The facts which can be discerned from the pleadings available on record reveals that a master license agreement was entered into between one Premchand Shah, SHA Shah, since deceased, who was the father of the petitioner, and the railway authorities on 5/9/2018. The said agreement, as per clause 1.1, stipulated that it would commence from 1/11/2015. In clause 3.1 of the said agreement, it has been mentioned that the agreement would commence on the commencement date which have been agreed to by the parties as 5 years and subject to the provisions of clause 3.2, 8 and article 16 shall continue until a period of 5 years from the commencement date, and if not terminated or expired, would be renewed on mutually agreed terms. In terms with clause 3.2, it is seen that the tenure of the license shall be initially for a period of 5 years with a provision of a further renewal for a period of another 5 years on satisfactory performance and payment of all dues and arrears, and withdrawal of court cases, if any. It has been categorically mandated that the renewal will not be a matter of right. Further to that, it is also seen from the said clause 3.2 that a licensee must apply for renewal minimum 6 months in advance before the expiry of the contract. And the no dues certificate from the concerned authority must be attached along with the application for renewal. Which shall be submitted afresh along with the renewal application. Unfortunately, the father of the petitioner, late Premchand Shah, it is Satu SHAHD, expired on 19/5/2019. It is not known when the petitioner thereupon applied for transfer of the license in terms with clause 19.4 of the said agreement. However, perusal of Annexure 5 to the petition reveals that on 27/7/2020, the senior divisional commercial manager in reference to an office letter dated 12/9/2019 and the petitioner's prayer made in a letter dated 6/7/2020, whereby the petitioner was advised to submit the succession certificate for transfer of the wheelbarrow license at Falakata railway station within a period of 7 days from the receipt of the letter, failing which action as deemed fit and proper shall be taken by the railway administration. From a perusal of the said communication, it also reveals that on the earlier occasion also the petitioner was advised to submit the succession certificate, which the petitioner failed to do so. The petitioner thereupon, on receipt of the said communication dated 27/7/2020, submitted a communication on 3/8/2020 stating inter alia that he could not submit the succession certificate till now due to the prevailing situation of COVID-19 pandemic. And as such sought for time to produce the succession certificate before the senior divisional commercial manager Full stop. On 9/9/2020, the senior divisional commercial manager taking note of that the petitioner failed to submit the succession certificate as directed by the communication dated 27/7/2020, directed the petitioner to remove the wheelbarrow from the Falakata station within 3 days from the date of receipt of the said letter. It further transpires that on 2/7/2021, it further transpires that thereafter, on 2/7/2021, a notice inviting tender was issued inviting from inviting tenders, inviting bids from partnership firms, companies, self-registered self-help groups, sole proprietors, firms, or any individual, etc. for the provision of catering vending facility at the various stations on general minor units, (GMU), to the respective reservation category over the APDJ division for the tenure of 5 years only, renewable after 1 year, subject to satisfactory performance and payment of all dues during the contract. From a perusal of the contents of the said notice inviting tender dated 2/7/2021, there is no category of wheelbarrow. However, in respect to Falakata railway station, Falakata platform number 1, there is a tea stall number 1, tea stall -1, earmarked for men, and a snack bar earmarked for women. It reveals thereupon that the petitioner had approached this court by filing the instant writ petition. This court, by an order dated 4/8/2021, passed an interim order to the effect that the tender process initiated under the NIT dated 2/7/2021 shall not be finalized in respect of the wheelbarrow stall standing at Falakata platform number 1. The record further reveals that on 23/8/2021, this court issued notice, and the interim order thereupon has been continued from time to time. It is also seen from the records that an affidavit in opposition has been filed by the respondents through the Senior Divisional Commercial Manager, Northeast Frontier Railway, Alipurduar Junction. In the same affidavit in opposition, apart from taking various preliminary objections as regards the maintainability of the writ petition, it has been stated, it was stated The petitioner failed to establish or provide any evidence for any claim in the event of his father's death on 19/5/2019, who was the original licensee during the unexpired period of the agreement. It was further mentioned that the original contract agreement expired on 31/10/2020, that is, after the death of the original license. But the petitioner claimed the transfer of the license on 6/9/2019 in his name, in violation of para 21 of the Catering Policy 2010, dated 27/7/2010, and clause 19.4 of the agreement dated 5/9/2018, which clearly spelled out that a license can be transferred in the name of the spouse of the legal heirs for the unexpired period of the agreement in the event of the death of the original licensee. It was further mentioned that the petitioner failed to establish his claim as a legal heir of the original licensee authentically with any legal documentary evidence as required under the Catering Policy of 2010, which is evident from the office letter dated 27/7/2020. Further to that, it was mentioned that the original licensee did not declare the name of his spouse or any legal heirs at the time of entering into the contract with the respondents. It was further mentioned that the petitioner is not entitled for transfer of the license of the original licensee in his name without any authentic documentary evidence under the Catering Policy of 2010. The railway rules, as explained in the letter dated 27/7/2020 and the office letter dated 19/9/2020, the petitioner did not fulfill the actual requirement. It was further mentioned that the contract agreement was executed in terms with the Catering Policy 2010, which was superseded by a new Catering Policy 2017, which was specifically barred the renewal of such vending units. Further to that, it was stated that after the expiry of the said contract agreement dated 5/9/2018, the railway had taken back the physical custody of the said units. Further to that, it was also mentioned that the notice inviting tender where in respect to stalls like the where in respect to the stalls where in respect to other stalls and the stall of the petitioner was not included. Next. I've heard the learned in the backdrop of the above pleadings, let this court therefore take into account the respective submissions of the learned counsels for the parties. Mr. R. Dubey, the learned counsel appearing on behalf of the petitioner, submits that by virtue of clause 19.4, the spouse of the legal heir of the original licensee has a right to be transferred the license for the unexpired period of the agreement. He submits that once the license is being transferred, the legal heir steps into the shoes of the original licensee. And under such circumstances, by virtue of clause 3.2 of the agreement, he has a right to be considered for renewal. In that regard, the learned counsel have drawn the attention of this court to a judgment of the Delhi High Court in the case of Indian Railway Catering and Tourism Corporation Limited versus Moyuri Ben M. Chotai. Reported in SCC online. You don't look into it. I don't give them suggestion. Sorry. Those type of submissions I can do. Reported in 2018. SCC online, Dell 9760. It is the case of the petitioner, learned counsel for the petitioner, that in the said judgment, the interpretation of a similar clause dealing with the term unexpired period was decided by the Delhi High Court, holding inter alia that by virtue of clause 7, which is parameter to clause 19.4 herein, the legal heir steps into the shoes of the original licensee and therefore entitled to the renewal. The learned counsel, however, submits that the same arbitration proceed, that the same judgment was rendered in the proceedings under the Arbitration and Conciliation Act 1996, whereby damages were awarded by the arbitral tribunal, which was, however, not interfered with by the Delhi High Court. In the proceedings under Section 34 of the Arbitration and Conciliation Act 1996. Anything more? Mrs. U. Chakraborty, the learned standing counsel of the railways, submitted that the agreement was entered into, that though the agreement was entered into on 5 9/2018. But it was effective for a period of 5 years with effect from 1/11/2015. And accordingly, the period ended on 31/10/2015, 20. The petitioner did not produce any document to show that it has a right over the land, that he did not produce the legal heir certificate prior to the expiry of the period, in spite of various opportunities so given, as could be seen from the communications dated 27/7/2020 and 9/9/2020. It is under such circumstances that immediately upon the expiry of the period on 31/10/2020, the railway authorities have taken over the vehicle. What is that? They have taken the physical custody of the unit. Further to that, it is the submission of the Learned Counsel for the respondent railways that clause 19.4 only gives a right to the spouse of the legal heir of the original licensee to continue with the license for the unexpired period of the agreement only, and not beyond that. Under such circumstances, any right of the petitioner on the basis of the agreement dated 5/9/2018 stood extinguished on 31/10/2020. The Learned Counsel further submitted that the question of renewal does not arise, inasmuch as not only from a reading of clause 19.4 of the agreement, the right of the spouse of the legal heir is only for the unexpired period of the agreement only, but also from clause 21 of the catering policy, it would be seen that the renewal is only permissible in the case of renewal of license on transfer to legal heir may be permitted only in the case of licenses belonging to reserved minor category catering unit as per the existing instructions. The Learned Counsel further submitted that as per clause 15 of the catering policy of 2010, the reserved category in respect to Schedule D, in respect to category D stations, which is the present station, are only scheduled caste, scheduled tribes, other backward classes and minorities, and the petitioner does not belong to any of this. That's your solution. Sure. I've heard the Learned Counsels for the parties and have also duly perused the materials for record. For the purpose of proper adjudication of the instant, for the purpose of adjudication of the instant dispute, this court finds it relevant to quote some of the relevant clauses of the agreement dated 5/9/2018. The said clauses are clause 3.1 and 3.2, as well as clause 19.4, which are quoted as hereunder. court had, in the previous segments of the instant judgment, have duly mentioned the contours of clause 3.1 and 3.2. And as such, to avoid prolixity, this court is not repeating the same. As regards the clause 19.4, it is clear that the transfer of the license to the spouse of the legal heir would be allowed only in the event of the death of the original licensee. It is also mentioned that the license can be transferred in the name of the spouse of the legal heir for the unexpired period of the agreement only. That too, with the personal approval of the Chief Commercial Manager, Railway. Now, the same clause 19.4 emanates from clause 21 of the catering policy of 2010. The said clause 21 being pertinent to the dispute involved is quoted hereunder. From a perusal of clause 21, it includes page 92, page 92. From a perusal of the said clause, it is show that the contents of the said clause are parameterial to clause 19.4. Apart from the above, apart from the said, there is another stipulation in the said clause 21, which stipulates that a renewal of license on transfer to legal heir may be permitted only in case of licenses belonging to reserved minor categories units as per the existing instructions. The said clause, therefore, the said stipulation, therefore, makes it clear that the renewal would only be permissible in respect to those reserved minor category units and not others. In the backdrop of the above, if this court takes note of clause 15 of the catering policy of 2010, it would be seen that clause 15.1, clause 15.1, 15.2 and 15.3 deals with reservation in categories A, B, and C. However, clause 15.4 relates to categories of D, E, and F. As the station in the instant proceedings pertains to category D, the reservation is only applicable to scheduled castes, scheduled tribes, other backward class, and minorities. It is also relevant to take note of a pertinent submission of Mrs. U. Chakraborty, the learned counsel appearing on behalf of the railway, to the effect that the railways have discontinued the wheelbarrow, the licensing of wheelbarrow, as per the catering policy of 2017. Is it? And as such, the question of issuance of any renewal to the petitioner does not arise, as at present the railways do not permit wheelbarrows in the railway platforms. You do not.
So they are not continuing.
There's no more wheelbarrows.
license for contractor.
No new license or they are no,
No new license.
you say that. I've not been issuing, it's relevant to take note of the submission of Mrs. U. Chakraborty, the learned counsel appearing on behalf of the railway, to the effect that the railway administration is phasing out the wheelbarrows pursuant to the catering policy of 2017, and no new licenses have been issued in respect to wheelbarrows. In view of the above, in the backdrop of the above, therefore, it will be seen that admittedly the petitioner could not submit any legal documents, any documents entitling him for the transfer of the license during the period when the license was valid, during the pendency, during the period when the license was in operation, that is with effect from 1/11/2015 to 31/10/2020. It is also not known what the what steps the petitioners have taken thereafter, inasmuch as it is only after the issuance of the notice inviting tender, that too after almost 3 months thereafter, that is only after the issuance of the notice inviting tender on 2/7/2021, the petitioner has approached this court on 3rd of August 2021.
Inviting the tender.
That is what I also see. Okay, you take your seat. Please see it. This court is also further of the opinion that from a reading of clause 19.4, this court have also taken due note of clause 19.4, which stipulates that a right is conferred subject to necessary approval upon the legal heir oblique the spouse for transfer of the license during the period, for the unexpired period of the agreement only. The said clause 19.4, as stated, comes into existence from clause 21 of the catering policy of 2010. This aspect would also be clear from the fact that the catering policy of 2017 does not contain any provision for renewal. Clause 21 also categorically mandates that the renewal is only permissible renewal of license on transfer to legal heir may be permitted. It's only permissible in case of licenses belonging to the reserved minor catering units as per the existing instructions. This further makes it clear that the right which is conferred upon the original licensee under clause 3.2 is not available to the legal heir oblique the spouse of the original licensee upon his death. Except those coming within the ambit of the reserved minor catering units. This court have also further taken note of apart from the above, it is also clear that the exercise of the right has to be done within the within as per the agreement. The materials on record shows that the petitioner failed to exercise his rights within the period when the agreement was valid. And as such, after the expiry of the said agreement, the petitioner could not have exercised his rights for transfer of the license and thereupon seeking renewal. Under such circumstances, this court finds no reason to interfere with the impugned orders, or as well as also to issue any directions as sought for in the writ petition. Before parting, this court, however, finds it relevant to take note of that the judgment delivered by the Delhi High Court in the case of Indian Railway Catering and Tourism Corporation Limited, Supra, cannot be made applicable to the facts of the instant case, taking into account that in the proceedings, that the said judgment was delivered in the proceedings under Section 34 of the Arbitration and Conciliation Act 1996, wherein the Delhi High Court did not interfere with the arbitration award only on the ground, did not interfere with on the ground that the said award did not contravene the public policy. In that view of the matter, the instant writ petition therefore this court finds no merit in the writ petition, and accordingly the petition stands dismissed.
Yeah,
Yes.
the way I took in court number 7, I took time up to 3. Because of fixing the matter too. So that would be for me.
No. That matter is finished today. I have to issue notice if it is so. You want, we can take it up after 4:15. The court rises. That court. No court sits. I sit till 5 o'clock.
I took time up to 3. So
No, Mr. Mahmood, no court sits till 5. I sit till 5. So after 4:15, you do it. Okay. Don't worry. The matter has to cannot see the next. Yat whole এই ডেট কেইটা নাথাকিব 27 in year এইটো নাথাকিব only thing will be that he exercised his rights on 30/10 one, and secondly there is nothing mentioned in the petition that the earlier lessee had exercised the right for extension as required under 3.2.
So there are two restrictions, there are two restrictions.
Did he exercise the right under 3.2 earlier, 6 months? In that case,
He expired just 20 days prior.
that is one, he had to express his rights under 3.2 6 months before the termination. The period ends on 30 days. So that is one.
Fought for changing because
He had to exercise his right that he wants to continue 3 months, 6 months before. That is not there.
that is not mandatory.
There- huh?
That is not mandatory.
My goodness, all other clauses which helps you is mandatory, others not.
I am that respect. After which.
Okay. Fourteen, top of the list. Next time, I have to find additional evidence.
Huh?
Minor actually established one minor dispute factory minor on that area. And the municipal board of minor. Bonaigaon municipal minor issued minor closure notice to minor till 98. And minor.
Then
Now they have issued minor trade license, renewed trade license minor. And I have to go
who have issued?
and
Who have issued the trade license?
that the same authority minor, chairman minor. Bonaigaon municipal board.
There is a stay operating. That is why we vacate the stay and then we'll see whether he issues the trade license any further.
Around 1 week and a half, and finally. This is for me minor. 6 to 9 also 5 minor.
Who is appearing? For you have not taken the NOC from the pollution board.
But they have also minor subsequent issue minor.
You have got the pollution NOC. The learned counsel appearing on behalf of the petitioner. Show me the impugned order 17/2014. Where is the NOC?
And also, minor 38 minor. Is 30.
These terms, no objection will be raised from anybody against the applicant or the establishment and not required for public interest. Is on what basis? How are these terms, why are these grounds? Who is appealing for Bongaigaon municipality?
One by the is the CM Naloy and KP Nekam.
Huh?
There are three matters. Is the CM Naloy and KP Nekam.
Now, whether there was any notice issued? No, I don't understand. How can there be for a bakery? No objection will be raised from anybody against the applicant establishment. Means if somebody raises an objection, you will finish. Huh? And not required in public interest. Madam, tell me, how are these types of conditions being put out there in a municipality license? These licenses is issued under what provision? What license is this? This license, why is it required? It's a trade license. There can be only a trade license. Any other license is required as per the municipal act.
For the establishment of the daytime on the NOC, the history of the NOC file.
Where?
NOC is explained by the.
No. Why is it required? What type of license? Under what provision? Regulation of factories and workshops. Not to be established without the permission. 228.
Factory, etc. not to be.
228. Huh?
229.
229.
P. 1P.
1C.
1P. P for Poland.
Oh, P. Bakery including, yes. Within such local limits as may be fixed by the board at a meeting, no place shall be used without license from a board which shall be renewable for any of the purposes namely said, and shall not be withheld under reasons which is intended to establish or maintain to be offensive or dangerous to persons residing in or frequenting the neighborhood. The board at a meeting may subject to restriction, if any, as it may include extend the provisions of the same to yards or the goods or trade. The means shall be consistent with the Indian Petroleum Act. No such licenses unless the same provisions to be complied with. Only ground is which it is intended to establish or maintain would be offensive or dangerous to person residing in or frequenting the neighborhood. That's it. Now, how can a bakery or a biscuit factory be something like that?
Waste. Waste emanating from
Hmm?
the waste aspect.
Smoke? Waste?
Yes, sir. Food waste,
To make it dirty?
that could be a possibility. Smoking, petrols, oh my God. There is another- Nothing done that, up to 25 kg, the limit is there, might have 25 kg. Up to 25 kg, might be the orange fire, orange.
Let us see then the show cause. Yeah, public, on receipt of public owners smart verification, it is found that the sound pollution created by the generator and also smoke nuisance generated from the, we are causing threat of human health and so and so, which is highly observed and thus violated so and so. Moreover, you have not taken any permission to have to install DG generator set in your bakery unit. Well, your DG generator is a silent one.
Yes, madam, because the.
Where?
That thing 86 match. 86 madam.
Are you operating the DG there? How? Have you got the permission from APDCL? Where? Because in your reply, you categorically say that I have applied for the permission from APDCL to install and operate DG set, which shall not be operated until and unless permission is received. Have you got the permission from the APDCL? Hmm? So what is wrong? Show me the noise, the pollution control board. NOC. NOC of the pollution control board. Where is it? You don't have it. You don't have pollution control board. For getting the benefit of a stay, you have done all these things. We get the stay. Merely giving you a trade license is different. Trade license is only for the purpose of collection of tax. Nothing more than that. You said now. Now there's a pollution control board certificate. Where is it? This is only for 2019. You in 2023 you want to bring this on record. The trade license would not help. Sorry. Trade license would not help. You know, this matter has come up in the top of the list. Did it come up only yesterday? For the first time?
On the, I'm mother, he's mother, outside mother, our mother.
Huh?
We went to 1 week.
So you have closed down the factory. Close down the factory if he's in Bihar. He wants to run the factory on the basis of an interim order. How many people have been affected because of this? Then
I mean, you are very straight,
hmm?
you are very straight. 1 week.
What?
Meanwhile, you come and
You vacate the interim order.
for 1 week.
No, these are 2014 matter. It doesn't look nice. After 2014, this matter has come. Then
I'll file my city matter, then
the learned counsel appearing on behalf of the petitioner submits that there are certain developments which have taken. Which he wants to bring, have taken place during the pendency of the petition, which he wants to bring on record by way of filing an additional act. Yes, Mr. NNB Chaudhary, you come here. Now your junior was not able. Now tell me, you don't have a pollution control board certificate? What green? No, that green is gone. I'm not concerned now. Now there is a violation. You have applied. Why did you apply for a pollution control board? In your reply, you have mentioned it. What? No, but here it is not necessary. They can very well say, are you saying that it is not necessary for a green industry? Pollution control board certificate is not necessary. And if that be so, then why did you take a pollution control board certificate in the year 2019? Secondly, you say in your reply that you could not operate your DC generator till you receive the APDCL permission. Why are you operating, getting a stay? Take a stay from this court and do whatever thereafter. I could have stated, okay, 9 years have gone by. Let us be happy, do whatever you want. I've got your stay. Is it something like that? Yes. Tell me. For what? I was giving you time till you came. You have now spoiled the case of the petitioner. Tell me. As you are a senior, so obviously you will be knowing this. Merely because it is a green in NEIIP, does it mean that you are excused for everything? There has been a lot of other environment clearance, these notification, environment impact assessment notifications. There have been a lot of amendments thereupon. In 2004, 1994, there was one, and thereafter in 2004, there has been. And thereafter, every year, there is coming up every time. Are you saying now you don't require an environment impact assessment? Page? Yes. Page 66. Yes. You are hereby directed to provide new service connection as per the condition. How does this have any relevance? We are concerned with the DG there. You kindly come here to your reply. No, kindly come to your reply. In your reply, you categorically say, kindly see page 97.
have any consent for the mention in the MOC. Something necessary to clear. And keep on tender as per the discussion of the pollution control board. I hereby apply for permission from NPCL to install and operate the same. Which shall not be operated until and unless permission is received.
Now, do you have the permission? No, Mr. NND Chaudhary, not further. Now tell me, do you have a APDCL permission? Then how are you operating the PDCL? Because you have obtained a stay from this court.
No permission is required to set up the.
Go for what? Tomorrow, 2 o'clock? And your junior produces this in 2013. Our consent to operate, which has already, which is no longer there. This was valid for 2018-19. Where is your now the present consent to operate? And why do you need this consent to operate if it is your submission that it is a green industry? Mr. Chaudhary, trade license is for levy. Does it legalize? Then you don't expect this type of submissions from you. Order to let the matter be listed immediately after the vacations on 30 November 2023. It will affidavit from calculation. Yes, Mr. Warbier.
That is small issue, my lord, non-payment of higher charge, but here in the case, my lord, the affidavit filed by the respondent, my lord, one says, my lord, that.
Higher charge of what? With whom? Railway?
No,
For this, for political.
one order for maintenance.
Huh?
No one order for maintenance.
Requisition.
My.
Who is paying for the departments? Political.
Government has filed two affidavits, my lord, I have filed my reply on.
What does the government say?
My lord, the government respondent number says, my lord, in paragraph 13, my lord, they say out of 8 cases. Bills have been referred as the superintendent of police.
Following bill have been referred to the superintendent for making payment, though the requisition was made from their end, but the vehicles were placed under the list of the SP.
Remaining 4 bills could not be
I
paid
mean,
as there is no original record of the bill or the petitioner was asked to submit the record of bill for making payment.
Cannot be made as the government payment. Then
Then, my lord, another affidavit has been filed by the respondent number 4, my lord. They are also on the same para 5, my lord. He admitted on the para 5 of respondent number 4, my lord. With regard to the statement made in para 4 of the respondent says that the bicycle bearing number 12 to 12 have been requisition hired for convey escort on the roads from so and so on different location from.
it has been requisitioned by whom? OC Dugunmukh PS.
Requisition by my lord, I have annexed my lord, Lordship can have a look, my requisition by lord, annex of 1. It has been requisition by my lord, district magistrate. That is the respondent number 3.
Officer in charge of Dugunmukh police station.
My lord, they hold up the vehicle from the road, my lord, and they take it and afterwards they the certificate of the district commissioner and.
Huh?
Also, can you have a look, page 12 of the review. One is the district commissioner, one is the officer.
So who will pay?
District magistrate has.
Hmm?
this scheme is test. And now they are showing responsibility from one shoulder to another. And very small amount.
How much?
2,83,000. Right from 2014. 2012.
Yes, madam, what do you say? Who is appearing for NCH?
That may not comment.
You can appear for the district magistrate NCH. You give the original
I
bills.
have given my, otherwise, fellow, they can reconstruct also. I have given my evidence also. The bill which I have submitted. Like this matter, can it be like this matter subject to lawsuit condition? I'll approach to the authority with copy of the rate petition, enclosing all the documents. Let them do
What documents?
bills, everything, requisition order, everything is there, including my representation.
No. You have submitted the original bills.
Yes, that is, it's up to them, my lord, they have to take. Original I have to, photocopy I have. Now, my lord.
So they don't have the original of 4
Four, they say,
out of 8.
out of it.
4 they have.
Four, they
4 that you have not got that amount, 1 lakh
nothing,
30,
I've not got a single file.
and remaining 4.
Remaining 4, my lord, I have annexed, my lord, both requisition order also and bills also. They can reconstruct it, right? If I give my copy of the requisition, they can they can call me to put my signature, I can put, because this record is very much.
Why do repetition has to go to them?
My lord, I have annexed all the,
So you don't have any additional copies?
yes, I can.
No, when you make bills, don't you have counterfoils?
No, my lord, like this only receipt for the lawsuit, and they have a look on study.
Page?
How they give my lord receipt,
Yes.
they give like this, my lord, receipt. Receipt.
No, this is only received by Nazir. That's a different thing. This is a bill being submitted by you.
Yes, sir.
So if it is for this period, for these 2 months, just for example, page 32, date of requisition so and so and so and so. If this is for a period of 55 days.
Right.
Now, whether it has been taken, forget about the bills. If they don't have the bills also, they will have the records that they have requisition. You have the originals of the release and acquisition order.
Yes, yes.
That too original you have.
Yes, I have an election.
No. These originals you have. Annexure 1.
Election one I got.
This page 18, do you have it? Huh?
Yes, must be, I am.
Receive original copy. Yeah? No. Annexure 1, Annexure 2, all these things. You have the originals or not?
Election 2 original, I have to give them.
These Annexure, what I'm not saying about Annexure 2 series, we'll consider that is a bill. But Annexure 1 is there.
Yes.
Do you have the originals or not?
Must be having.
No, don't say must be. Because I will ask them to make it, because then if Annexure 1 is there, because it stipulates the date of requisition as well as the date of release.
Contact manual, 1 minute time.
No, you take it. We will have it on some other day. We will have it on Thursday at 2 o'clock, 2 p.m. You get your instruction. Is the matter on Thursday at 2 p.m. On which state Mr. J. Baldwin shall obtain the necessary instructions as to whether the petitioner has the originals of Annexure 1. Because with that, I think it can be reconstructed.
Yes, yes.
The bill is there or not, it is there. You can give it another bill also.
Yes.
Bill, it is your document.
Fine.
But that other document is not your document, it is a document of them.
Fine.
But if you don't have the original of the one, then the question is what to do.
Fine. That-
That is the problem. Yes, Mr. B. Sharma, what are you doing?
Hearing matter to Mumbai,
What is that?
petitioners, they are agreed by decision of the regular party to levy panel amount charge against the instead. They have come against the order, but it's otherwise a covered matter.
Actually, madam, the railway have levied, madam, panel levy charge, without issuing 48 case, my lord. And wide publicity is also important, my lord. Before making final letter, and wide attention is also supported by the judgment of the Honorable Guwahati High Court, Honorable High Court Allahabad, and my lord High Court Delhi. So I have that decision, my lord. So the important procedure which requires to be followed is in terms of railway rates from the circular, my lord, which clearly says that before making final letter, they have to issue 48-hour notice. And my lord, wide publicity is also important. So,
Which was not done.
Now,
this is right.
Hmm? Covered.
notice was given, otherwise it's a covered matter by a decision of the Sonapur Court between the same parties. There is a provision for filing appeal before the authority agency decision. Now, their entire claim is based upon a railway board circular. They cannot approbate and reprobate at the same time. They cannot say that they adhere to only those provisions of the circular which are favorable to them, and those are.
Oh, like the earlier matter,
Yes,
where you wanted clause 3.2 on top, but not on the bottom.
it provides for an appeal, and they have, my lord, themselves submitted themselves to the authorities of the railway in another matter. It's covered, well covered. And even otherwise, I have got objections with regard to maintaining the process. Even after taking that objection, the initial stage, they have not corrected those lacuna. Because it's a company, my lord. There is no resolution of the board of directors. There is no resolution of the board of directors that they are going to file this petition before the court, and there is no resolution of the board of directors authorizing the petition number to serve the affidavit and file this. Taking this till at the threshold itself. Till then, so even after
Complaint everything, madam, I have already annexed the board of resolution in my additional affidavit final article. And my lord, the contract is between my lord, the Indian Oil Corporation and the petitioner. The Indian Oil Corporation, my lord, has transported 11,642 grams of bitumen from Haldia Dock Complex to Sanchavada. So there is a tender, my lord, in between the petitioners and the Indian Oil Corporation. And accordingly, my lord, approval certificate and my lord, work order has been granted in the name of the petitioner. So they have already complied with my lord, and I have already served the copy to the council.
So your preliminary objections has gone down.
subject to correction number.
Hello, we'll have it some other day after vacation, because anyways, I have so many matters out there so many judgments have been given. Those things need to be corrected and signed. It takes a long time.
Afterwards, because subject to correction. Lordship would be examining the decision making first. Lordship would not examine the correctness or otherwise of it. Yeah, there is no decision of the authority. If she is agreed by an order, let us file an appeal before the authority. After the decision comes, Lordship can examine the correctness or otherwise.
But is the order not a decision?
That is.
Maybe that order is appealable. That is another aspect. But are you saying that the order is not a decision?
It's because it's an
That
admitted
is-
position of fact that there was.
No, is the order not a decision having civil consequences?
It's a decision at the lower.
You say that you won't abide by the order, or you would not implement the order, she will be happy.
Before any approval, my lord, actually need to look into case, my lord, that whether they have complied the mandated requirement or not before moving panel evaluation. That needs to be.
And that is a question of law as to whether there has been a compliance to the provisions of the statute.
There is an admission on the part that we can levy the normal damage charge, not the. There is a default on the part. That's a
Period of my lord, second phase of corona, my lord. During the second phase of corona, my lord, they imposed panel evaluation.
Corona have led to a lot of litigation. Huh?
More particularly in case of the railway.
Good for you. One more additional matter.
Nowadays, not a good, this is not good. Yeah, very good.
Now, one thing is that you say the CJC needs to be abreast with the railway rules and various circulars and all. It becomes very difficult when you don't have a regular railway council. It becomes very difficult.
I admit that.
Hmm.
I was a little bit lucky because I was associated with Honorable Justice retired TK and thereafter you can have. I've been dealing with this matter for last 20 years. So many things, but the CBSE comes.
So that is the big problem, that if you are not abreast with this, and more particularly that day I was taking up one matter. That was a matter which it's again parted, I think it's fixed on 17th. That was a matter pertaining to haulage charges. Now, on the basis of an instruction guidelines, the Container Corporation of India had imposed certain amount upon that.
Something.
Huh?
Yes.
Some lady steal or something. So that was the case. But the fact that if it was a railway council who is appearing there, the thing would have been different because of the fact that he would have known about the rate circulars and all. So without knowing about these rate circulars and all, it becomes difficult for that council. The council for petitioner also, you see, many like Madam knows in and out, he, she, Amit Goel and all these things, they know each and everything about the railways. And however, some other councils, they may not know the intricacies. There are so many circulars, something like the education also. Every time education, you have a different circular.
They will follow the having their own set of rules and everything.
Yeah, so that is another thing. It's a very difficult thing. Then that day only when there was nothing out there, then I said that I saw that railways rate circular, wherein there is a particular clause. Now the question is whether those guidelines can override this rate circular. Where categorically 126(1)(a) categorically mentions that this cannot be done for those where there is no misdistribution. Now, by way of a guideline, can you do that? No.
So far as this declaration is concerned, now there is another statutory problem, probably section 66 of the railway.
No, it is there. But here is the case where there was a miss in the entire reg. There was certain misdescription by some of the consignors. Now, what has happened? That very consignor sent various consignments to various consignees. Now, as regard this consignee, there was no misdescription. His rec was okay, perfectly okay. But by this, they have imposed the 4 times. Now, what has happened? The consignor is happy. He's sitting. Because in view of 74, the consignee becomes liable for the amounts the consignor has to pay.
Probably for the mixed rate, not a.
No, these counts, and it is an evident fact. There has been no misdescription in the case of the petitioners. No misdescription. Then under such circumstances, how they would be bound? In view of the rate circular, it says on 126(1)(a). Now, on applying that, a guideline has been issued saying that, no, 4 times you charge.
I am also appearing in similar matters. I have got 2 cases in similar line, but these are pertaining to the railway. Probably that matter which Rashid is talking about is not concerning the railway. Probably it's.
No, it is done by the Container Corporation.
Corporation.
No, but railways are there. So railways is made a party.
Secondary railway.
The second one, because what has happened, the first one, there was no problem. The challenge was against the container. The second one was as regards
Circular.
where the circular has been put to challenge, so the railways are part. So there, I think Mr. R.K. Dev Chaudhary is appearing. And the petitioner did not take up that ground initially. So I asked them to file an edition, they filed an edition, and so I'm asking for the railways. Because on that day, Mr. R.K. Dev Chaudhary said that they could not. But putting it on the basis of just a verbal thing, it would not be proper. So I've asked him to file an appeal.
decision in that matter would be having a hearing on criminal cases or if that is allowed, if the circular goes, my matter.
No, this matter will have far-reaching consequences on the parties later on. Because what has happened for the last 8 years, MS Ignos have been stored by them. They have not released it. Now what will happen to those MS Ignos? It all must have got rusted out. And do you know for how much? They have been only charging them 2,27,000. The value of the property was 57 lakhs.
And at that point of time, 2015 case.
Yeah,
At today's rate.
yeah, so. And all must have gone. Now that container corporation have been seen this, that they are in a weaker position, now comes up, then kindly allow us to release it.
They won't be taking the delivery. Let's suppose that.
Obviously, they can't, they won't. There's nothing left. We'll have it on some other day. After vacation, later day. Yes, what is that?
But 2013 letter, my lord, my son was died. Said the chief it's on the last occasion you will see.
Oh, that one. Show me. Huh? Oh, there is a postmortem report, if I remember. Because in the postmortem report, there was a direction to take an FSL.
Yes.
What happened?
That FSL report could not be placed out. In fact, they.
So was it done or not?
That also they could not.
Because there was a direction to do it.
But
Because in the postmortem report, it was categorically mentioned that as regard this, it needs to be done.
one case, I got from a person that Human Rights Commission, they went for Human Rights Commission also. In that matter, there is no such violation regarding.
But the Human Rights Commission did not consider this very vital aspect of the matter, isn't it?
Just they don't have record that one.
Where it has been mentioned that you have to go for an FSL. That aspect of the matter has not been taken into consideration by the human rights most probably. Isn't it? Because that is a very relevant, because here you say that he was okay, but he died out of poisoning or something to the effect. And the poisoning can only be known from the FSL.
Postmortem report might have called is not as poisoning.
You love the person.
You love the.
That is what, no, he alleges poisoning. The postmortem report says how it is done, but to rule out poisoning, that FSL was to be done. And that FSL report, whether it was done or not.
That's something is not that.
No, but the fact is whether it was done or not.
That is
Yeah.
also. One discussion.
No, it can't go on like this. No, the instruction, if you can't produce it, then we have to take a call.
Despite on the last day, we also was pleased to record training on this course and thinking that there will be a forensic examination report and consequently go ahead with it.
We'll have it after vacation, huh? Fix a date, record this order.
Earlier communication says that concerned you take your official matter as forwarded the matter to. Realistic matter, people have that. Came up to the hospital authorities also. Yes, I just want to make a can I have a claim for a direction to the director of forensic medicine so that if there is such any record, it will be taken and in respect of that unemployment case, this number is there. But last question.
Now, in the ARC, in the Assam Human Rights Commission, there is a copy of the FSL.
That is not reflected in
Now,
the.
here it says, moreover, the Honorable Chairperson Assam Human Rights Commission was also requested to make necessary arrangements to make available the final cause of death or the FSL report along with the status of the said ARC case in respect of the deceased so and so. In response to a letter, the Assam Human Rights Commission so and so is collated and the same is enclosed for your kind favor. Pertinent that no FSL report is submitted directly to the jail authority by the forensic as they submit the same to the superintendent of police of the jail district as well as the investigating officer.
That's conversation is not this commission or the copy data. It is was 90% that is the but no such record.
It will matter to list the matter on the so this code by the order dated order to date. What is the date? 14/9/2023 had directed the junior government advocate, Ms. Srimati Meghali Burman, to produce the FSL report the forensic report. If any. It was also mentioned that this court, if would draw appropriate presumption if such report is not produced. Today, Ms. Burman have produced a communication issued by the Inspector General of Prisons, wherein it has been mentioned that the forensic report was not submitted directly to the jail authority by the Forensic Science Laboratory, as they submit the same to the Superintendent of Police of the district, as well as the investigating officer of the concerned case, and to the Civil Hospital Authority. It is further seen that the additional district magistrate Golaghat had, by the communication dated 9/10/2023, informed the Inspector General of Prisons that in regard to the unnatural death, the magistral inquiry was conducted to inquire the cause of the death, report of which is enclosed herewith. It was also mentioned that the officer in charge, Golaghat, have also been directed to submit the forensic examination report. The said communication, however, does not enclose the report of the ministerial inquiry, nor the communication which was issued to the direct officer in charge of Golaghat. Be that as it may, this court fixes this matter on 21st of November 2023 for final disposal. It is made clear that if in the meantime, the responding authorities would be at liberty to produce the forensic examination report, if any, and failure to do so, this court shall presume that there was no forensic examination done pursuant to the observations made in the postmortem report. List accordingly. The instructions which have been produced are kept on record. Where is it? It is not here.
That copy is the typo copy is working record writer.
No, in this copy, it is not there. The documents so produced by Ms. M. Burman, she is kept on record and marked with the letter A and B. A and B. Oh. So and so the learned counsel appearing on behalf of the petitioner submit that the petitions have become infructuous, and as such, the petitioner would not like to press the same. In that view of the matter, the petition, both the petition stands closed on withdrawal. The interim order, if any, stands vacated.
For the court cases, for- Okay.